CCJ Appeal number CB0001 of 2005, Barbados Rediffusion Service Limited and Asha Mirchandani, Ram Mirchandani and McDonald Farms Limited.
My name is Henry Ford, and I appear on behalf of the appellant, the Association, the Howard Dollar, and the CCJ. The Honours, I appear for the conduct in association with Dr. Richard Cheltenham, Mr. David Thompson, to Ms. Anita Stewart and Ms. Shelley Jones.
Thank you. Yes, we were given notice of an application with regard to an objection to the jurisdiction. Is that right?
That is correct.
Yes, but let me first indicate to you that we have looked at the document which was filed, and we considered whether we ought to allow this objection to be taken at this stage. Council will be aware that when leave was applied for, the court raised with the council the question of jurisdiction, whether this court had jurisdiction to entertain the appeal, assuming that leave were given. And we had some submissions made by Sir Henry Ford on behalf of the applicant. But the respondents did not choose to make any submission with regard to that. Indeed, the point which they took with regard to jurisdiction, quote unquote, although I don't think it was really a point going to jurisdiction, was that the application was out of order because the Court of Appeal was a procedural change. That has not been challenged as far as I can see. Nor has there been any attempt to challenge the implications which the transitional provision gives rise to. But the reliance has been placed wholly on Section 20, I think it is, of the Interpretation Act. 29, I'm sorry, Section 29. Which deals with a situation where an act is repealed and rights have accrued under that, and it provides for the preservation of those rights. Well, we are not giving judgment, as we have not heard argument, and we will not be hearing argument. But I think I should mention that it does appear at first blush that the rights which are referred to there are substantive rights as opposed to procedural rights. And what we are concerned with here is not a substantive right, but a change of the court to which your appeal is to be directed. That, as stated in our judgment, in our view, is a procedural change which is not affected by Section 29, as it appears to us, without having heard argument, to the not affected by Section 29 of the Interpretation Act. Anyway, to sum it up, we think it would be wrong to allow the matter to be raised now. The respondents had the opportunity to raise it. They were given every opportunity, and as I say in the judgment, they did not accept the implied invitation to argue the point, and it is far too late now. A notice which I think was filed on Friday, was it Thursday, to seek to raise that point. As I said, we would have been concerned if, on the face of it, the matters which were raised in that notice by way of objection to the jurisdiction appeared to challenge seriously the reasoning on which our judgment was based. But again, admittedly, without the benefit of argument, it doesn't appear to us that it does so. So we are not going to allow the matter to be re-argued. And we will now proceed to hear the substantive appeal. Sir Henry?
Thank you, ma'am.
Please, Your Honors, it is possible, given the history of this matter, to shorten the oral submissions which I propose to make before this court. We have filed a skeleton argument, and I will ask Your Honors to take into account as well the skeleton arguments that were filed on the application for leave to appeal, since in several respects, they answer some of the matters being raised by the respondents in their skeleton arguments. If I may, in a way, set out what I think are the major issues facing this court and arising out of this appeal, is that we are submitting that the decision to strike out the appellant's defense in the circumstances constituted a miscarriage of justice and a violation of the applicable principles of procedure and law, and that the Court of Appeal erred in concluding that sufficient discovery was not made in the circumstances before the court. But let me contend that it is a well-established general rule that statements in a party's affidavit of documents are conclusive as to whether he has or had any documents other than those disclosed, except in very limited circumstances where it is possible from the affidavit itself or from some other pleading or other document in order to hold otherwise. But that, Your Honors, it's our submission that it is important to bear in mind at all times the distinction between general and specific discovery. A very important consideration which pervades the appeal and the responses is that the respondents have admitted that they have tapes from Voice of Barbados of the relevant songs which constitute their causes of action and made on numerous dates. And the question which the court must ask itself is whether there is still a fair chance of a fair trial being possible. Led by the order of the court made on the 9th of August 2005, we were given leave to appeal against the decision of the Barbados Court of Appeal made on the 20th of August 2004, striking out the appellant's defense for failure to comply with an unless order to file a further and better list. This is largely matters of procedural in nature, but if your honors will let me just briefly make reference to some of the pertinent background facts. The writ of summons was filed on the 28th of December 1990. The causes of action alleged was for claims for damages for libel contained in the lyrics of 3 calypsos which the respondents were alleged to broadcast over their radio station Voice of Barbados on frequent occasions between the period June 1989 to the date of filing of the writ on the 28th of December 1990. The action that I will submit followed the normal course until discovery. The defense was filed on the 20th of February, and an amended defense was filed by the 7th of October 1991, and a further amended defense was filed by the 7th of October 1992. If I correct myself, the first defense was filed on the 20th of February 1991, and amended defense by the 7th of October 1992. This defense did not admit publication of the words complained of. And that is one of the issues.
I may just interrupt you here, Sir Henry. The defense of qualified privilege appears to have vanished without trace, by which I mean that in the subsequent edition of the defense, the paragraph by which that defense was raised and which presumably was ordered to be struck out is not reproduced.
But I have a further amended defense at tab 13.
Yeah.
Which was filed on the 24th of November 1993. And at the top of page 80, my lords, in the record of appeal.
Yeah.
Yes. There was actually...
Does it appear in that document?
As to the order made by the learned Chief Justice? It was actually argued among the parties, and the Chief Justice made a ruling which is reported, and I think it appears in the respondent.
Yes, I know. I am not on that, but the practice, proper practice, surely is that if a pleading is amended whether by an order of the court or by the party whose pleading it is. And as a result, some portion of the pleading is ordered to be is to be deleted. Then that portion should be reproduced with a red line through it, shouldn't it?
Your Honor, Mr. President, that practice has been followed almost invariably here in Trinidad and Tobago, and is certainly followed in England.
Not in Barbados.
Hasn't been particularly, no. It's
Why? The
complaint was made that, well, at least it was reproduced but was not erased when the complaint was made.
It was not.
No, complaint was made that the qualified privilege defense was reproduced in an amended defense that was issued after the Chief Justice's judgment.
Yes, complaint was made about that as well.
But at least on that occasion, it wasn't deleted. It wasn't. There was no indication that it was.
Let me say that I have not, up to now, been able to get hold of all the certified copies of all the pleadings filed in this case. So there have been some matters that are not in the record, although I believe in the lawyers who settle the record try their best to put all that they considered relevant before this honorable court.
Is this the subject of a rule in Barbados? Or?
No, my lord. In my experience in over 40 years, some of us have followed it, others don't, and there's never been any comment on it, really.
I wonder if the Privy Council were aware of it. No, because it seems to be useful and sometimes quite important to be able to see at a glance how pleading has changed its shape.
Yes, my lord.
Sometimes the fact that a matter was or was not pleaded initially, or what was pleaded even though it was struck out, is a matter that of some relevance. And if I may suggest, I would not like to take on myself on this court the burden of overturning practice in Barbados, which has lasted, you say, for at least 40 years. But may I, at any rate, make a strong recommendation that what is the practice which has been always followed in England, which is the country from which our common law has come, and our rules of pleading, which, as you say, has been followed in more often than not, at any rate, in Trinidad and Tobago. I don't know about other Caribbean countries. Should be recognized as a better practice, and perhaps practitioners in future might consider whether they ought not to follow it.
Mr. President, we are grateful to you. I believe the new rules in Barbados are likely to be implemented from the 1st of April next year, and they will make a considerable improvement, I think, in our procedural rules. And we certainly, those of us who sort of have anything to say on these matters will draw that matter to the attention of the rule makers. But, my lord, if one wants to see what were the pleas, it's set out in the case which is reported at volume 1.
I've seen it. It's in the original defense,
yes.
Which we have on the record, which I had seen. But I must admit that when I saw the most recent defense, I had forgotten that I had not noticed, actually, that the pleading had been omitted.
Yes.
I did not realize that an important change had taken place.
Yeah. But there have been many developments since that ruling as well. So this case is overtaken by some changes in judicial attitudes and pronouncements on these matters.
All right.
Thank you, Lord.
I hope I have not diverted you from your course of thought.
I was making the point that the action was following the normal course until discovery. But let me say that a very material consideration for your lordships will be the state of the pleadings and what were the issues arising on those pleadings. It is noteworthy that at no time in the statement of claim damages were being claimed in respect of any broadcast over any other station operated by the appellants, and in particular the station Yes FM. And it is also noteworthy that in all three cases the lyrics were introduced by the same language, and these can be seen at tab 1 of the Judges Folder Volume 1 of the Record of Appeal Volume 1 at pages 2, 5, and 8. Well, then if I may merely take one of them, paragraph 5 at page 2. On frequent occasions since June 1989 to date, but particularly in June and July 1989, the defendant falsely and maliciously broadcasts and published often concerning the plaintiffs and each of them in the hearing of numerous listeners to their radio station Voice of Barbados throughout Barbados and the Eastern Caribbean the following defamatory words in the form of a recorded calypso entitled The Mad Chicken Song. And that same form of pleading is repeated in paragraph 8.
But do you is it your position that if this matter were to go to trial, and the plaintiffs were to succeed, that they could not get damages for the broadcast on the 28th of July and the 4th of August 1989, when the semi-finals and finals of the competition were broadcast live?
It's my contention in respect of the matter occurring on the 28th of July 1989. As I understand the pleading goes right up to the period of broadcast up to the date of the writ. But the specific allegation in relation to the causes of action relate principally to the causes of action arising from the recorded broadcasts over Voice of Barbados during that period. And it seems to me that if the issue of damages arise in relation to other matters, it would have to relate not to them as causes of action so far, but as evidence in relation to any issue of aggravated damages.
I'm not sure that you've answered my question, which I think is capable of a pretty simple answer. And that is it that you are saying that they're not entitled in this action to complain of the live broadcast of the Calypso competition because of the use of this word recorded?
Now that is a contention that we do make, that they are in relation to recorded broadcast.
Really. And you know, if this case, and this is, of course, an assumption which I'm making merely for the purposes of this question, but if the matter does have to go to trial, isn't there now going to be a further delay while perhaps an amendment is sought? And, you know, I think that this hasn't all along been understood. That one of the instances about which the plaintiffs were complaining, and complaining with some force, was the broadcast of the Calypso finals and semi-finals. Hasn't that been obvious?
Well, yes, it has been obvious that there has been a complaint made, and when I come to the plaintiff's list, I will certainly draw your lordship's attention to the relevant areas that arise.
You see, we are now in 2005. This case started in what?
Very good.
1990, 15 years.
Yes,
and I feel that, as I said in the judgment, that we should do everything to ensure that if the case has to go to trial, that it goes at a very quick pace. And I think matters like this, that if there is to be some technical objection to their including in their cause of action the live broadcast, because they have pleaded recorded here, I would be anxious to straighten that out, you know, here and now,
yes,
rather than have a summons to amend, which might take another year to get a hearing, and, you know.
I think,
judging from the track record of this case, that would not be outlandish.
Mr. President, I think you are running ahead of me. In some respects.
That way, you see, so that we don't fall behind.
No, we have no intention.
In this case, far too much.
Yes, Your Honor. Let me just say this, that as a matter of fact, one of the main submissions that arise from this is that the state of discovery on both sides, and also on the plaintiff's side, has been such that matters that should have been attended to by way of amendment had not yet occurred. A little late in the record, I will draw Your Honor's attention to the fact that in the affidavit, I think one of the affidavits of the first respondent, the point is made, for instance, that in relation to the Mad Calypso, that one of the verses on which the respondents rely have been omitted, and that therefore if they wish to rely on that verse, then there would certainly have to be an amendment. And I don't anticipate, Your Honors, that those amendments, if they are sought on either side, will take a whole host of time.
I think, I thought my impression was that we can consider this perhaps at a later stage if necessary. But I thought that what they had pleaded included the verses that were sung at the Calypso competition. Is that not so, Dr. Sheldon?
Yes.
Yes.
But then, if I may say so,
I think that
if I draw Your Lordship, Your Honor's attention to page 126 of the record. And this is the affidavit filed on the 13th of March 1995, paragraph 20 of the first respondent, Mrs. Mirchandani. The second verse of the said song was in error omitted from paragraph 5 of the statement of claim, and the plaintiffs will apply to add the said verse as follows.
I see.
So the point I'm making, my lad, notice has been given to us that the respondents will be applying, but up to now no application has been made.
Yes, I see.
So the resistance of the defendants, of the appellants in this case, has really not been tested, nor...
Which one? Yeah.
No application has been made. So that the state, which is a very material point in this case, the state in which the litigation was being conducted outside of very frequent satellite applications was such that both parties were missing deadlines and both parties were not as strict in complying with the rules at any stage. So that I could not, as a senior counsel, say otherwise before a final court of appeal, or in any court, indeed. And but it was not a matter of one side. We are still waiting for that and other applications to be made.
That's obvious, sir.
Yeah, but I will give your honors the undertaking that certainly we are deeply conscious from all of our points of view of the effect which delay is having on all parties, including any state of knowledge of parties to these matters. So, I'm not sure at the moment that I can say to your honor, other than we will facilitate as quickly as possible any amendment requested. And we are prepared in our own way to submit ourselves to timelines in respect of any such matters. But we say that if I may go back to the part, that the highlighted words have to be kept in mind because they too become relevant to the issues that are being argued relating to live broadcasts. And it is not so strange that the affidavit of documents filed on behalf of the appellant spoke to the records that it has. Now, the first application for discovery of documents was made on the 23rd of June 1992, and an order for mutual discovery was made within 42 days. To be made within 42 days was made on the 7th of July. The respondents filed their list on the 15th of September 1993, and the appellants filed its list on the 23rd of November 1993, and a further amended defense on the 24th of November 1993. So that the history is such that, again, neither party were strictly complying with the rules of the court or with the time lags that were set. Again, that it is significant that the filing of these documents by both parties were done without applications for extensions of time. And no further step was then taken in relation to the list filed by the respondent until the 12th of October 1994, which is almost a year or just after a year after the defendant's list was filed. The step which was taken by a summons returnable filed on the 12th of October 1994 and returnable on the 13th of October 1994. And at that time, we submit that it's pertinent to the issues. Unfortunately, the only senior counsel appearing on behalf of the appellant had assumed the office of Attorney General and was in the process.
Well, a date for that, Sir Henry?
Yes, my lord. He assumed the office in September 1994. September 7th of 1994.
The exact date?
7th of September 1994.
Thank you.
Mr. Ford, there's just one, I would just like to make one observation. I think there were 3 summonses that had been filed in relation to having the defense struck out for failure to comply with the order. I think one was filed on the 16th of September 1993. That was a summons for directions, read the mode of trial, and also that the amended defense be struck out for failure to comply with the order of Justice Husbands made on the 7th of July 92. Then I think another summons was filed on the 12th of October 94, which was returnable, as you just said, for the 13th of October. And in that summons, they asked that the defendant's managing director file the affidavit verifying list and for further and better list of documents.
Yes.
Then there was another summons filed on the 30th of December 94, seeking to strike out the amended defense and also again to file the affidavit verifying list, which had already been inadvertently mentioned, but it had been filed. I wondered, why was it necessary? Of course, you can't answer that, maybe the other side should. So you had 3 summonses asking for the same relief. And I think you said that the counsel for the appellants assumed his new duties in September of 1993.
Yes.
But at that time, the first summons had been filed on the 16th of September 1993.
Yes. The first summons has been filed. The first summons was filed on the 16th of September 1993. Let me go to that summons, my lady. But let me say that the affidavit of documents was filed on the 15th of September 1993.
Yes.
And the summons for the striking out, one of the allegations was there was no affidavit verifying the list of documents. And in actual fact, an order was obtained for such an affidavit to be filed. In truth, an affidavit had been filed, so that order had to be abated.
Yes. On the 16th, in the summons of the 16th of September 93, counsel appeared for the appellants. That was returnable, I think, for the 12th of October 93.
Your Honor, I can't answer immediately. I don't want to answer anything that is untruthful. I'll get the chronology. I haven't got the order before me. I can only say that to the best of my knowledge, the counsel at that time was not appearing at some of the applications, as you will see later, so that the main order made for discovery for a further list was made with Mr. Simmons not appearing. And the next really significant presence of counsel appearing on behalf of the appellant occurred in January 1994, when Mr. Hal Gollop,
January 1995.
sorry. When Mr. Hal Gollop, with I believe six weeks call, took over the conduct of the action at that stage.
So that was returnable for the 3rd of January 1995.
95. He appeared at that stage. Yes, thank you.
First, they're not all the same.
Yes. That's all.
So that one had my report once they were filed.
So I wonder what that was. 94. Not, yeah.
I don't think so. Maybe this was a further request. Then, to file with someone to try to do it. So it was not, event radio covering the same thing. No. There are.
I have a statement.
Sir Henry, there is what appears to be an inaccuracy in your written submissions in paragraph 7, which I think you should perhaps correct. They're not made. They said that you say there at the top of page 5. Is it so? Yes. The first complete sentence. Nevertheless, the appellant, pursuant to the order made on the 24th of November 1994 and filed on the 10th of January 1995, filed a further list on the 1st of March 1995, containing and so on. Do you have that in front of you?
Yes, yes.
Well, that isn't accurate, is it?
Just
it wasn't pursuant to that order that the order made provided that a further and better list should be filed within 2 weeks. No list was filed within that time, or at all, up to the filing of the summons on the 30th of January for the unless order. And you omitted here any reference to that unless order, and it was in response to the unless order that the further and better list was eventually filed. But it certainly was not pursuant to the order which had been totally disregarded.
Yes. Yes.
Far from doing anything in pursuance of it, the defendant totally ignored it.
Yes.
Well, I know whatever may have been the state of his representation at the time, of its representation, but that is the fact.
When was that order filed? The order of which I speak on the 24th of November 1994 was the order made by the Honorable Sir Dennis Williams.
Yes.
And the order in respect of that was filed on the 10th of January 1995.
Whenever it was filed,
yes.
Sir Henry, doesn't matter. It was not in pursuant of that order that your further and better list was filed.
The further and better list was filed when on the second order made by the Chief Justice.
That's right.
So if I apologize if there's a misunderstanding onto that by the use of the word pursuant. That would be incorrect.
Totally
incorrect.
Yes. You have totally omitted any reference to
yes.
this order.
I think a little later they say the respondents challenged this list on the basis of non-compliance.
But you know, Sir Henry, I think that you've got to face the facts. The facts are that this cumulative effect, what appears to have impressed the courts in Barbados, is the cumulative effect of the failure of the defendant to respond properly to the court's orders. And it started really with the order made on that date. What is it? In November 1994, the 24th of November 1994. It continued with the response to the unless order.
And if I may look at this, I thought I handed in last time a state of chronology which sets out clearly each state of event.
Yes.
If everyone wanted to see the course, I would wish to see if I could find that chronology that was handed in the course.
I think most of us have made our own, actually.
Excuse me,
I think most of us have
read it, yeah.
I didn't bother too much.
No, I had to handed in that chronology anyway. But let me say that, as I said, neither party seemed to have been strictly following the orders made or the time factors. And I can't argue otherwise before your Lordship's court. But it was not a one-sided matter. And when steps were being taken to file orders, likewise, those orders were being filed as well outside of the time allowed. So that I'm not sure that if I may answer directly, Mr. President, your statement that the effect of the court gave to those failure to file orders on time seemed to have been a neutral effect, because the Court of Appeal commented in its judgment that delay on both sides had occurred and nothing falls in relation to that delay. And that is a direct statement of the Court of Appeal itself. So that it would be my submission that it wasn't that at all that seemed to have towered within the minds of either the judge below or the Court of Appeal in coming to a decision in relation to whether the defense should be struck out or not and maintained. In my humble submission, this would seem to be so. But we contend, my lord, that crucial to an understanding of what was required by the order of the Chief Justice was a distinction to be made between the application which was before him and his ruling on that application. The application before him was an application which the Court of Appeal found was for general discovery. And we say, my lord, that if it was such an application, then obviously when the Court of First Instance and the Court of Appeal came to consider it, one of the questions which they had to ask themselves are, what are these documents which should be disclosed which had not been disclosed according to that order? So although the order was not appealed from, in my humble submission, the question of the legal framework within which the order was made would still have been of significance.
Yeah, but Sir Henry, that legal framework would have included the affidavit of Asha Mirchandani, which made reference of specific documents which, in her view, ought to have been disclosed but had not been disclosed. The Chief Justice, when he made his order, would have had in mind that affidavit.
Well, that is that. Can we really, even on a balance of probability, really come to that conclusion? Because if this is so, that was never indicated in his order. It would be very careful in his order if there were specific documents which had been mentioned, that he would have adverted to those specific documents. So that is, the law is absolutely clear in my submission that in construing an order, one has to give the benefit of the doubt to the person in an instance like this who has to carry out that order. And one would have expected at that stage, whether the test is being done at the time of the allegation of non-compliance, that what was the order being made should be clearly stated. And in my humble submission,
yes, sorry, finish.
In my humble submission, at no stage was there a specific mention of specific documents which had to be disclosed.
Well, there was no specific mention in the order. But let us assume a situation, not this one, but a hypothetical situation in which a party has made discovery but has failed to disclose certain highly relevant documents which are in his possession. And an application is made, and let us say that they belong to a specific category of document, and let us say that there is evidence that this particular category of documents ought to have been in his possession. And let us assume that the other party, wrongly perhaps, makes an application for an order for a further and better list and does not apply under Order 24, Rule 7, whatever it is, for specific documents. But the order is made, it isn't challenged. Now, would the party against whom the order was made not be required, as part of the further and better discovery, further and better list, to include these documents which he had not disclosed? Even though
sorry, I lost to do what?
The more appropriate order would have been the one asking for specific documents rather than general discovery.
Yes, Mr. President, based on the question that you have asked and that you have framed it. But you have already, in that asking that question, stated that there was evidence that those documents existed.
Yes.
And that therefore...
Let me ask you this then, to get cut to the chase, as they say. When your radio station discloses in an action, in this action, this defendant disclosed that it had records of these three calypsos, is that not a strong indication, first of all, that it played those records?
And that was never, the fact that records, that it had records was never denied, and those were disclosed.
I'm not finished, if you forgive me.
Yes,
it would, I thought, have been obvious that they were not records. The records were not for their own amusement. They were for broadcast. And is it not also a matter of common sense that in 1989 a radio station would keep a record of what it had broadcast?
And it is made quite clear that they use a vinyl record, and that...
Oh, no, not what they used to project
Yes.
the song, but that they kept a record. Would it not be presumed that a radio station would keep a record for whatever period of what it had broadcast?
Now, let's take what it had broadcast, the words of the song, because the words of the song that it broadcast, Mr. President, I'm trying to understand, because...
Let me explain it.
Yes.
I thought it was quite simple.
Yes.
But there are two things you see. When you are in a radio station, you have the equipment to send something out on the airwaves, right? Now, that is what you have a record for, to play and send it out. But in addition, normally I would have thought you, as a precaution perhaps, would keep a recording, an audio recording of what it is that you have put out on the airwaves.
Well, as I
And
understand...
you, in fact, I mean, it's not difficult to understand what I'm saying, because this is, in fact, what happened. As Mr. Finance admitted, that there was a master tape which recorded everything that came over the radio station in the course of a day.
Let me go to Mr. Finance affidavit, because I think Your Honor's jumping ahead of me again.
I want to keep it like that so we move on.
You're jumping ahead of me again. Let me go to Mr. Finance's affidavit. And that is at 169. At tab 29 at 169.
But I want to try and find it there because I have my notes there. What date is there? The first one is in this.
That's at tab 29, page 169, filed on the 8th of November, 1995.
8th of November.
28th of November, 1995. 28th of November.
Yes. Okay, thank you. Yeah. What paragraph?
I would like to deal with the paragraph starting at paragraph 11, if your Honours will let deal with that. Page 172. The first point I must make on his affidavit is that the affidavit is made from paragraphs 12 there onwards, reserving, subject to the reservations and without waiver of rights. So that the first point, I know you're trying to push me on a bit, that I was making is that he is doing this without a reservation of rights, because it is a strong part of the case that although the order was not appealed, it would be most unfortunate from the point of view of justice if the order flows through in such a manner as to penalize a person in circumstances where that order could not itself by itself show the person exactly what he had to disclose. And that too was a consideration for the judges when they came either at the court below or the Court of Appeal to determine in their own mind what are those documents. And why I was saying that that is fundamental to this case is because one had first to look at what did the affidavit, the first affidavit that he filed, disclose. What did the second affidavit add, if anything at all? And then to determine what did the judge himself have in mind. How should we interpret the order of the judge, saying that unless you comply with this order, then you will be struck out? And to comply with the order, one had to deal with documents that had to be disclosed. And therefore, what were those documents? What we are asked to say, as I understand it, is that the Chief Justice had in mind that he accepted the documents which were in the affidavit, the first affidavit of Mrs. Mirchandani, were the documents to be disclosed. And that both at the court below and the Court of Appeal, the finding was that those were the documents to be disclosed. You ought to have had them in your possession, and that therefore, if you haven't disclosed them, then you are in breach.
But is it that it was documents of that type rather than something as specific as you know, as you are suggesting? You know, like again, I don't want to be going ahead too far, but I am thinking of the case which I think you cited, or maybe the other side, of the balance sheet, and then that supposes the existence of supporting documents, and I think that what Mrs. Mirchandani's affidavit did was just to seek to confirm the belief that in a properly run radio station there must be some sort of records, however, whatever form they took, of what was put out on the airwaves.
Well,
and that therefore what was being expected, whether rightly or wrongly, for the moment, let's not leave aside, but what was being expected from the defendant was the disclosure of some documents of that type.
Mr. President, sir, I think I've answered the approach that should be taken in paragraph 16 of my submissions, and answered the question of the primary documents. Let me put... The application, since the application to file a better and further list was made under Order 24, Rule 3, and not under 24, Rule 7, one would have expected the respondents to show from the documents disclosed in the appellant's list, or from admissions of the appellants in the pleadings or otherwise, and without the assistance of any affidavit, that the appellant has other relevant documents in its possession, custody, or power. Now, I stop there to say that, Mr. President, you have used the example of where there is a primary document And the primary document itself would speak to other documents. Take a financial statement. Obviously, a financial statement is composed from other documents which would become, may or may not be relevant in the matter. And it seemed to me I have no difficulty with the principle established in Kent Coal Commissioners in relation to the fact that if an affidavit shows in itself or some pleading that there are primary documents that lead you to the trail of other documents, yes, in such circumstances, the court has made orders either for general discovery, as in the Kent Coal and those cases, or it has made an order for specific discovery. And that is why we contend that the plaintiff, the respondents, could have come by way for specific documents or classes of documents.
But, Sir Henry, if I may intervene at this stage, if your clients took that view, why didn't they appeal this order, saying we don't really know what it's all about, we want specifically to know what we're supposed to disclose? And could I put it to you that you didn't do that, and you did not need to do that, because it was obvious from the Chief Justice's order of the 24th of November what was required. Counsel for the defendant did not appear, as it records, but it does record that the document that the Chief Justice read was the affidavit of Asha Mirchandani of the 12th of October 94. That only has one substantive paragraph, all the rest are formal ones. And in that substantive paragraph, Mrs. Mirchandani spells out what she wants to see. Now, any counsel of 6 weeks call otherwise, seeing the order of the Chief Justice, knowing it's based on that affidavit, and knowing there's only the one paragraph in the affidavit, must surely read that affidavit and see all these specific matters that Mrs. Mirchandani would like information about. Did these documents exist? So to suggest that you didn't have a clue what the Chief Justice wanted and therefore were just scratching around is really being rather evasive, is it not?
With respect, Your Honor, it's not evasive, because I take the point in this manner. One would assume that the Chief Justice himself would have inspected the affidavit that was filed. And that affidavit that was filed is normally in law conclusive. And it's conclusive unless, and you cannot contradict it by a further affidavit, unless you can point to something in that affidavit, in the documents disclosed, or in a pleading, that there are other documents which exist.
You appealed his order, should you not, if that was the point you wanted to make, whereas you seem to accept it.
With respect, I accept that, but the order hasn't been appealed, and it hasn't. I accept that.
The issue arises: is this appeal a collateral attack on that order, which ought to and should not and was not appealed?
I realize that that is the matter that is concerning Your Honors very seriously. It may be an attack, if you wish to put that in hyphenated records, on the order, but it is not an attack on the judge who made the order. The point is that at that time when the first order was made, there's an absence of senior counsel. It is made in the absence of the appellant in this case. And in the circumstances of the case, there is an attempt to comply with whatever order the Chief Justice has made, although that attempt is being characterized as being insignificant in the circumstances. Look at the conduct of the counsel who took over was not to file any affidavit at all, not to omit to file an affidavit, but in actual fact to file an affidavit doing two things. One, giving further documents that he may have considered to be relevant, and those further documents were 3 letters which have been described as insignificant. But they are also showing the understanding that one had to do a continuing disclosure right throughout the case, and not only at that time. Secondly, since he must have looked at the pleadings, because if one looked at the pleadings, what was being asked about was records. And it is just say that to substitute a record for tit for tat rather than a tape is not, in my submission, to show the necessary fairness in balancing what was being done, because your case was being pleaded on the basis of a record. And that was answered. This was not of a person who was flouting the court of order completely, who is throwing...
I think the statement of claim is based on recordings, which could be tape recordings or vinyl recordings. As I understand it, one of the problems with one of the songs, at least, is that allegedly the defamatory verses were on the tape, but not on the recording, particularly this tit-for-tat one. So essentially, it seems your further and better list was a further and worse list, because you said you hadn't got the tape, all you had was the vinyl recording, on which apparently the defamatory verses don't appear. So it was worse from that viewpoint. And these letters, as you say, were inconsequential letters between lawyers about adjournments. And none of the points raised by Mrs. Mirchandani in the affidavit on which the Chief Justice alone based his order were properly dealt with.
Well, at what stage is your Honour saying properly dealt with? Because...
Just in the further and better particulars list.
That particular list?
Yeah.
No, and understandably, I do not think they would have been dealt with in the circumstances in which the order was made. If there was... Because there is nothing in the preceding affidavits which in law, maybe a wrong understanding of the law, are conclusive. So how is it being interpreted?
So, Sir Henry, you're saying that if the Chief Justice had actually specified these 5 points that Mrs. Mirchandani raised as a specific discovery matter, then it would have been fair enough for you to deal with them. But because he made it a general order and didn't refer to them directly, but only implicitly, you could ignore it.
Well, I think I'm asked to get into the mind of the learned Chief Justice at the time that he did it implicitly. We are talking if I am not sure that he did it implicitly.
Well, he referred expressly to her affidavit,
yes, but
which contains these matters, so implicitly he must have based it on the matters in her affidavit.
That
only had one paragraph of any substance.
That's the only affidavit that was filed at the time, and it is standard form in any order to say upon reading the documents or upon reading the file, so that one can emphasize, because an order refers to the fact upon reading the affidavit and upon hearing Mr. X that it is ordered. That immediately implies that the Chief Justice was himself saying these are the documents that had to be disclosed. They had to...
Why otherwise would he have made the order? I mean, that was the only thing that he had in front of him, surely. This affidavit with these points in.
Well, I've already conceded that the order ought to have been appealed, but it was not. I have gone further and said that the correct, in my humble submission, position was really there should have been an application, to be fair to all parties, under Order 24, Rule 7. And alternatively, another way of approaching the matter was for interrogatories in relation to the issue to have been...
So Henry, quite rightly, you're pointing out what should have been done, but you're treating those things as if they ought to have been done. And in a sense, I suppose, you're saying, well, because things were not done properly, we can really ignore the Chief Justice's order. Ideally, it should have been this way, that way, and t'other way. It wasn't. No. So we'll just put up a few things, and that'll be that.
With respect, Your Honour, I'm not saying to ignore the Chief Justice's order. I have just myself submitted to this court that one should not imply more than can be implied in the Chief Justice's order, that there was another interpretation of that order that one could look at. Secondly, that in addition to that, that in the circumstances of this case, any lawyer who was looking at the matter, like the litigants, would be in doubt as to exactly what was being asked. And thirdly, that there was an effort being made, maybe unsuccessfully, Mr. President, you are asking me to respond, an effort being made to file an affidavit. It was not a case in which no further affidavit was filed at all. If no further affidavit had been filed, then the interpretation of that would clearly have been that there is a perverse and obstinate refusal.
Which affidavit are you referring to?
The affidavit filed by Mr. Not Mr. Finance. No, I haven't reached the Mrs. Finance stage.
Okay.
The affidavit filed in which it is said that only a record of tit for tat was substituted, which Your Honor, Mr. Justice Hayden says made it a position worse. That is what I am responding to. If that is thrown out of the window, if no order was filed, nothing was filed at all, then obviously the conclusion is that you are ignoring the court. But if you file something, even if you file whatever you filed is an effort in those circumstances, then that is a consideration that had to be borne in mind as well.
I suppose my key point really is that you seem to be ignoring the points raised by Mrs. Mirchandani's affidavit, upon which I think the only reasonable explanation for the judge's behaviour is he based himself on that. And yet you ignored those points. You did produce a so-called further and better list, but you chose to ignore those points on the basis that if those points were to be raised, they should have been done by specific discovery rather than general discovery, which is treating yourself as if your appeal had succeeded and this general order was ineffective.
Remember that I've put forward the arguments which I think would have gone through the minds of counsel. I came into the matter at the stage at which the application to strike out was being made, so that one is dealing against that sort of background. As I said, I've conceded that the Chief Justice's order was never appealed, and that is most unfortunate, because in a way now we are bearing the burden of that event occurring. And but the point is that still flows through in my submission to the duty of both the trial judge and the Court of Appeal to examine all of the circumstances, and not merely the circumstance that to imply automatically that that order demanded that there should be a disclosure in relation, or some answer in relation to the specific documents mentioned in the affidavit of Mrs. Mirchandani. So that was my response, and I have said, and I submit again, that it is well established that the order should tell the defaulting party precisely what he has to do. Yeah. Especially where the consequences of further default are draconian.
So, Henry, may I just ask you again whether you agree or disagree that a court would be entitled to assume, in the absence of evidence to the contrary, that a radio station such as Voice of Barbados would have some sort of tape or a recording of what it had broadcast in the course of a day.
But the affidavit speaks to
I'm
what...
not on the affidavit now, I'm just on...
Whether common sense says that.
Common sense would dictate that that was more likely than not.
But, Mr. President, I really would not like to go on record as saying either yea or nay to that question, given the standard at which people do business in most of our countries. They may have kept, for instance, BBS, I think, is on automatic pilot.
Yes, well,
And I believe at that time in 1989, Yes and 4 was on a similar automatic pilot. What I understood was normally kept was what has been disclosed in the attached to the affidavit of Mr. Fernandez is a log. And if one looks...
Not on the log,
Yes.
not specifically. I mean, in this, we are dealing now not with a music station, but we are dealing with a station in which there would be quite a lot of talk of one kind or another. I don't know whether in 1989 call-in programs were as popular in Barbados as they are now.
Days of our lives.
But I imagine they would have been not unknown. And given the possibility of exposure to libel actions or slander actions, and for all sorts of reasons, I would have thought that prima facie, at any rate, one would expect that such a recording would be made and kept for some limited period. Is that not reasonable?
That if you look ex post facto in 205, you may say that given the plethora of actions that most of the press have been confronted with, that today I would expect that to be a sine qua non. But in 1989...
Is that a more innocent age, you think?
What's that?
15 years ago or 16 years ago, but really, I mean...
Well...
What's the same risk and so on?
There may be the same risk, but there's been a revolution in telecommunications. And one has to accept that and recognize that that has also happened. So that I'm understanding, Mr. President, you to be saying that the finding that the order was made by the Chief Justice on the assumption that they would have been keeping some recording.
Well, that assumption would have been confirmed to some extent by the affidavit of the Mrs. Mirchandani,
yes.
The first respondent.
But
so that, I'm looking at it again. I don't know whether you, once the disclosed documents indicated that these calypsos would have been played on the radio station, as I think they do, then it's not a very big step, is it, to finding, at least provisionally, that there would also have been a recording of what was played, including these 3 songs.
Well, there is a record, and the records were disclosed in the list. In our list, we said we had a record of the 3 songs.
No, Mr. Henry. I mean, you keep reading me all the time.
No, I'm not reading. I haven't read that stage.
So you are misreading what
I'm
saying,
misreading you, yes.
Misunderstanding. I keep telling you that I am not, when I talk about a recording of what has been played, I don't mean the record used to produce the music. I mean a tape of what has been played on the airwaves, what has been said, all that has come out of the station for 24 hours. That's what I mean. Which is what, in fact, was kept. Let's face it.
Let me go to the affidavit. Let me go to the affidavit, perhaps, and explain what is being said in the affidavit.
Even in 1989, master tape.
If we go back to the affidavit, Mother.
Which affidavit?
The affidavit of Mr. Fernandes, page 172. Before I do so, let me say that among the things that was asked for in Mrs. Mirchandani's affidavit, which accompanied the application to go to before the Chief Justice, was the library records. But with respect, what assumption can one make, because one keeps the library, that it would have a relevant document, and if so, what document relating to these matters? I think it was in one of the cases, OM, OC and OM, which is said, well, if you seek discovery asking Justice Coleman for everything in the library, that is not only unreasonable, but really unoppressive, but it is not what discovery is about. So that when one says that the Chief Justice made it based on her affidavit, if I go back to the affidavit.
Well, it means everything in the library pertaining to this particular matter, not widely everything in the library. It would have to have some bearing on this particular matter.
Yeah, but did the Chief Justice make an order saying what in the library? And I know it may sound to judges very difficult that you haven't appealed an order, but you are you are speaking about the order and the defects of that order. But the truth is that one has to weigh the order not only by Mrs. Mirchandani's affidavit, but one has to weigh the order as to how it is being construed by people who have to make those decisions. And the books are replete with the literature which criticizes. That's why it's said in Avalon and the other cases that there has to be a certainty in orders of this nature, and that is where most of the problems come in cases of this nature. And this is exactly a case of the sort that one has the problem there.
The point is that if one is going to visit any penal consequences on a party, one would have to have a very precise order before one can impose any penalties. I think that's the point.
That is the point, Your Honor.
So one has to start constraining the order.
That's right.
Based on exactly what is here, rather than what might have been might have happened in previous affidavits, or what the Chief Justice might possibly have had in mind.
That's right.
He has to say it precisely on the face of the order. That is the point that I'm. With respect, I agree with that, and that is what is remarked on in the cases, in some of the cases, because each case depends on its facts. But that's remarked on the Avalon case, which I've cited at paragraph 16.
Before we go to that case, but following up on that approach, the order did require that, among other things, that the defendant disclose all I'm paraphrasing, all relevant documents that had been at any time in its possession.
Mm-hmm.
Not so?
Yes, that's what it said.
And it is now admitted that the defendant did have at one time a relevant document in the form of a master tape on which would have been recorded their broadcast of these calypsos.
If your lordship could draw my attention to the specific paragraph,
yes, certainly.
Which you're
certainly. Just give me a chance, I'll find it.
You have to read that again. Mr. President, are you referring to paragraph 12.3 on page 173?
I have a different makeup to yours. We'll review it in a minute.
Perhaps this is paragraph 12.9 B and C, and perhaps 12.10, where there's a tape that advised should be excised.
What page is that?
Page 175.
175.
Not on the excise one, but on
all right. Paragraph
9B and C. There's some logotapes there which are used for broadcasting purposes or record purposes.
I don't think C is I don't think the C is in point, but B is.
Logotapes.
Logotapes were and are kept for 2 months.
Yes.
And then if you start at paragraph 9, such logotapes as the defendant had made or does make, you know, it's almost like I'm pleading. I wonder why.
Had
made or does make,
on the last
or are not relevant.
On the last
is in question. Because the only labels on logotapes were and are the numbers 1 to 60, which represent the one. So what?
Yeah.
Who is it? I mean, why? How can he determine what is relevant? Let me. Logotapes were and are kept for 2 months, after which they were and are recycled. Isn't that a clear admission that they were logotapes at one time?
One has to read the whole of the affidavit, which has been described as being cleverly drawn. So too are the affidavits of the plaintiffs.
But we're looking at
yes,
it now.
Yes, I know you're looking at this now.
Let me tell you frankly,
yes.
This U2 argument I must tell you, doesn't cut much ice with me. If we are dealing with the other side, and there's some application or some criticism to be made of them, we will certainly will listen to whatever you have to say by way of criticism. But I cannot see how one party can excuse his shortcomings or its shortcomings by saying, well, not only me, I mean, look at the other side. They have not behaved so well either.
No, Millard, I never took the statement that they were cleverly drawn as a criticism. I took it as a compliment. So, Mr. President, sir, I took that.
I think that you're being, if I may say so, Sir Henry, I don't think you're as naive as you.
No, well,
I think
maybe
you
not.
appreciate that there is a little sting in the tail of that.
Well, I'm glad that it's now explained to me, but the affidavits were obviously. The affidavits were obviously, as Mr. Fernandez said, at all stages he's been advised by his attorneys at law. And the statement which I was making
is cagey.
Okay, well, at all stages that's what he said, Milan. But I wasn't saying that it's U2, and that wasn't the U2 argument. I'm saying that at all stages these parties were in a position where their affidavits were obviously being prepared by their attorneys at law based on whatever evidence has been made available to them. And that's all.
But, you know, Sir Henry, one possible other approach might have been to say, even at the stage where there was the application to strike out the defense, to come to the court and say, yes, we did have logger tapes which were kept for whether it is 2 months or 3 days or whatever. And for whatever reason, we did not preserve them. We're sorry, but they're gone. And perhaps even at that stage, put in a new Schedule 2, which had something other than the word none.
Yes, Millard.
That might have been an alternative approach, might it not?
Yes, Millard. I'm going to deal with the word none in Schedule 2, and I was, in due course, say to the extent to which an admission can be made about the none in Schedule 2. But, Millard, if one reads the affidavit, we were doing more. In paragraph 16, at page 176, it's not merely to the court. What we state and verily believe that the defendant was willing to permit the plaintiff and the attorneys at law full access to the defendant's archives, library and premises, to examine all the records or other documents.
Yes. You know, well, that's nice, but is it practical? Not really. The obligation is on the defendant.
Yes, Millard.
To come forward and volunteer what he has had or does have. You don't have to go searching for it. That's, you know.
But Millard, that's it.
Discovery means. It doesn't mean search and discover.
Well, anyway.
It's disclose and produce.
Millard, if I deal with the issues raised on 9 and 10, one has to go back to the whole of paragraph 14. Sorry. Millard, I would like to start from paragraph 12. 12.3.
But, Henry,
Yes, Millard.
paragraph 14, is that confined to the SFM 10.4?
That was dealing with the SFM.
So that
This is you.
page 175 of the record, where they're talking about logger tapes, is that something that is specific to yes FM 10.4?
Yes, FM apparently had no logger tapes. If I go, I am the person who was responsible for the programming of Yes FM. It was and is partially operated by a computer-type tape system. While correctly referred to as a computer, since there are some computer systems, the system is more of an automated system which facilitates continuous programming without the use of manpower and does not operate like a normal computer. For example, there are no saving devices and/or printout facilities available. The computer stores no records. There are therefore no computer records which the defendant can produce. The computer is programmed to select tracks from various vinyl tapes for broadcast. A tape, therefore, is just a compilation of several records. These tapes are recycled on a regular basis. The computer operates from a number of tapes. These are in-house, which are made from vinyl records or compact discs. The computer has no memory or recording device to indicate which tracks were or are played at any given time on any given date. It is therefore impossible for the defendant to determine the frequency with which any track has been played from the computer. In 1989, the defendant did not have a log tape recording system for Yes FM. This has since been corrected from about the beginning of 1994. No logbook or register was or is kept in the library or elsewhere by the defendant. The only log kept by the defendant reveals the times of which there were segments of music, but not the actual names of music played. A typical example is attached and shown as Exhibit VF1. The only roster of...
So Henry, if I could interrupt, that exhibit relates to the Voice of Barbados, isn't it?
Yes.
But not to Yes FM. Am I right?
That's
The exhibit VF1 is not about...
Certainly.
Yeah, no, this is the long.
Is that Voice of Barbados? Yes. And that is a typical example of what is there and what, as he says, the only log which reveals the times at which there are segments of music, and that relates, it would seem, to the radio station, Voice of Barbados. Seems so to me.
You see, you had asked me to show you where there was an admission about the keeping of log tapes. We looked at one passage in the first affidavit of Victor Fernandez. But if you look at the second affidavit, his second affidavit, 4.7, 4.8. 4.7 says, 4.8. Sorry, the first plaintiff refers to a master tape. This tape is also known or referred to as the log tape. He knows what it is. He is giving it another name and admitting its existence. I again repeat the contents of my earlier affidavit, so on to and so on, and again state that the defendant has no such tape within its possession. Now, of course, what he carefully avoids saying is whether it has had such a tape. It is obvious that he did.
That's right.
In any event, it goes on 4.9. Mr. Newsbury could not have shown the first plaintiff the alleged log tape with the songs for the following reasons. A. 1. Log tapes are for previous days, including the days referred to by the first plaintiff, are stored by pausing there. So it is possible to identify which log tapes refer to which dates. are stored in an area under lock and key, accessible only by Mr. Roach. 2. The log tape in operation in the recording room on the particular day referred to by the first plaintiff would have recorded the events of that day only. And then 3, even if Mr. Dewsbury had access to the log tape for any day, he would not have known what songs were on the tape unless he actually played the tape. And for this he would need technical assistance from Mr. Roach and so on. Well, she never claimed that he played the tape. But isn't it clear from this that he is admitting that whether you call it a master tape or a log tape, that such a tape was made and kept, whatever period, of everything that was broadcast by the radio station on each and every day. And therefore, it seems to me that on the evidence of Mr. Finance himself, we can know for sure that there was something to disclose in Schedule 2, which was not disclosed in either the first or the second list, and which was clearly relevant to the matters at issue.
Well, if one goes back to 12.3, because whether there's confusion as whether it's talking of live broadcasts or otherwise.
No, it's not live. Nothing to do with live. This is nothing to do with live.
Of the first affidavit.
Of the first affidavit. At page 173. In any event, and at all material times, the defendant operated a system in relation to live broadcasts that if a tape had been made and used again, a portion of it would only have been used on the following morning, and then only such part of the tape as would illustrate the crowd's reaction to the winning songs. Now, we're here speaking about events that the allegation relates to the semi-finals on the 28th of July.
Again, forgive me. This has nothing whatever to do with what we have been looking at. Again, you are confusing the recording that is used for the purpose of sending the broadcast and the recording that is made of what is broadcast. The live tapes are used, or whatever it is, the live tapes are used for the purpose of sending out the broadcast. And that may or may not be kept. He doesn't know really whether the tape was kept or for how long it was kept. But what he is saying in the passage I have just read is something that is quite separate and distinct, and refers to the making of a tape recording of what is sent out by the radio station.
Let me go to her third affidavit.
You're not following it. If you want to play, you have people. You have a team.
Yeah. Okay.
Out of your radio station. There is also, of course, if you want to play a record, you will have a turntable in and you put the record on it.
Okay.
Something to do with the events, is it to do with the 19th of July, then with the day that she was finding about the 19th of July, and then you do with this,
I'm not sure whether the sounds
even on the, whatever means will
Mary, what's your comment on? I was wondering what relevance the letter which Dennis David Simmons had sent, dated the 18th of July 1991, where he said that they apologized for the song being played, but it was included in the computer of the station. That, no doubt, is the automated system which they operate. But doesn't that mean that at that time, certainly in 1991, they did have that automated system and a recording which was excised?
It is made from the vinyl. It's vinyl, yes. It's not a broadcast as such, in that it is made from the vinyl. And let me state that the letter is disclosed in the documents. What is not disclosed in the Schedule B, to which the learned president referred, was the fact that that computer document was excised, but that can't, in my humble submission, that was not, if they were...
Sorry, say that again. What was excised from what?
As I understand it, let me go to Mr. Simmons' letter so that I do not misunderstand.
No, but that letter has nothing to do with the master tape, huh? Nothing to do with the master tape.
No, but I was answering.
I know.
Yeah, I was answering. I'll come back to the master tape, because the master tape involves more than more than merely referring to the few paragraphs, the paragraphs to which Mr. President, you have referred. Right, sure. So I will have to deal with that a bit later for you. But I'm saying that Mr. David Simmons in 1991. 1991.
I know this case is old, but it is not that old.
I'm sorry. In 1991, he did respond to Mr. Mr. Williams' Yarwood and Boyce's letter. And those letters are disclosed. And if that is being relied on as a cause of striking out, in my submission, I think it has to be viewed in the context in which it occurs. There's certainly no concealment in that sense, because otherwise his letters are known to both parties. And if there's an omission from Schedule D, then that could be the only omission that would have occurred in respect of that letter.
But I was saying, it indicated then that at that time they did have in their possession, you said vinyl records of
tapings of the vinyl records, but the song itself is on the vinyl record. Because we really hear saying, is it possible for the words that were broadcast to be made known at any time? They constitute two areas about which the plaintiffs are complaining, it seemed to me. They're complaining of live broadcasts, particularly the 28th of July and the 4th of August. And they are complaining about songs played otherwise. As I understand the case as it is developing, the defendant's case is that, look, we made recordings from records, vinyl records. Those records are here. And those are the three records that are disclosed at the commencement.
But you see, Sir Henry, the advantage of the master tape, for instance, would be that it would contain the recording of the live broadcast of the Calypso competition, which is not on the vinyl record.
Yes, my lad, but then I have to go to 12.3 of the first affidavit, in which
Yeah.
173, he's speaking as to those broadcasts from 12.2. He says that the broadcasts, the events, which is really refers to the 28th of July and the 4th of August, were broadcast live. In any event and at all material times, the defendant operated a system in relation to live broadcasts that if a tape had been made and used again, a portion of it would only have been used on the following morning, and then only part of such a tape as will illustrate the crowd's reaction to the winning songs. Thereafter, the tapes, if any, of such live broadcasts would have been recycled, either immediately or within less than a week, since the technical quality of such live broadcasts are not usually of the required professional standard maintained by the defendant on its stations. The defendant would, however, continue to broadcast the songs by playing the vinyl records of them, and the defendant has already disclosed those records in its list of documents. In the circumstances, and having regard to all the inquiries and searches made, I say and verily believe that the defendant has no live recording or tape or logotape relating to the events or of the songs referred to in the plaintiff's first affidavit. And I verily believe that this defendant has made full disclosure. So that is in relation to the events.
Yeah, present tense, Sir Henry.
Excuse me?
Carefully chosen present tense.
Did he have? He said he just now has.
Yes, but it may be present tense, but these events of which the complaint are made, they're referring to situations in June and July 1989. There is no action before the court at that time. The action was filed in 1990. There is, however, the action is filed in 1990, 17 months after the letters written by the plaintiff's attorneys at law, in which the plaintiff's attorneys at law state that proceedings have been filed. Now, no proceedings have been filed. But at that time, the view taken by the legal advisor to the appellant, Mr. Simmons, was that the songs of which you are complaining are not libelous. So that we are looking at events that occurred at a time when no litigation is in position, and there's a difference between the lawyers concerned as to whether they constitute defamation or not. Now, Mr.
I don't understand the relevance to what I pointed out, that it's what was sworn to by Mr. Finance.
Well,
referred to what they had in their possession at the time when he saw the affidavit.
Well, let's go back to...
It did not condescend to deal with the Schedule 2. I don't know, we're spending a lot of time on this, Henry, and I don't know how much longer we are going to spend on it. But the point being whether or not there were in fact documents, at least two, which on Finance's own admission were relevant and had been in their defendant's possession at one time, and which should have been disclosed in Schedule 2, but were not disclosed. If that much were conceded. Even if it isn't, we can move on from there on the assumption that that is so. What then?
Yes, but
Because I don't think that from your point of view, or from anyone's point of view, that the mere fact that they failed to disclose these documents in Schedule 2 must necessarily mean that the defense was rightly struck out.
Well, I was answering the questions raised from time to time. I'm not trying to delay moving on, because that's one of the points I wanted to make to your honors, that let's assume, on the assumption that there were these documents and they were no longer available. In the circumstances, the failure to disclose in Schedule 2 doesn't necessarily lead to a sanction of striking out and not being able to defend the action at all. So that, and particularly in circumstances, and I'm afraid, lad, you must forgive me for having to say me too or you too, but in circumstances where, if you look at the affidavits, the plaintiffs themselves state that they do have tapes of the events, certainly of the semifinals. And I will, in this regard, the plaintiff's list of documents at item number 7, 32 to 46. Page 33, my lads, your honors. The plaintiff acknowledges they have tape recordings from Voice of Barbados made of the songs complained of the following dates: the 17th, the 18th, the 21st, the 24th, the 25th, the 26th, the 28th, and 31st of July, and the 16th of August 1989.
Yeah,
now,
I saw that, Sir Henry, but it doesn't necessarily follow that the tape that was made on the 28th was made when the Pickety Crop semifinals was in progress. It could have been made of the song being played at 10 o'clock in the morning on the 28th.
That is a possibility as well. So that what I would expect, therefore, that this is relevant to the issues. Now, if I am to interpret that, the clarity isn't there again. It could have meant as well that it was a tape of the live broadcast of the semifinals. And I emphasize that by the fact that in the fourth affidavit of Mrs. Mirchandani,
well, that's the one where she gives the verse, the missing verse.
that's the one where she gives the missing verse. Tab 32. Can't be 32. And her third affidavit, well, I think it is. No, it's not that. It's not the third affidavit, it's the fourth affidavit. Fourth affidavit. Yeah, that's me. Two 21, 225.
verse in 126?
126.
126 refers to the intention to apply to add the verse. Malad.
126.
That the
Is that the verse that it is alleged was sung during the
live broadcast? That's one of them.
And another
But there's another section of her.
significant occasion apparently was, I think, on the 19th of July, was it, when there was the commentary over the music, and one of the radio stations commentators made a specific reference, or is alleged to have made specific reference to the respondents, while the calypso was, one calypso was actually being played.
Yes, my lord.
And then promptly played a second one. That, of course, although I know it hasn't been pleaded as far as I've been able to make out, but it would surely be very helpful to them on the question of reference to the plaintiffs, which you have sought to dispute.
That's Melody.
Maybe I'm trying to going to try and cut short this this hearing if I can. You know, not cut it short in terms of terminating it, but getting you to deal with some aspects of the matter. One is whether the order, assuming that subsanction was called for, whether the order should have been limited to striking out those paragraphs of the defense which raised issues to which these documents that were once in your possession and were destroyed speak. Now, that is, of course, on the bid if we were to come to the conclusion that the order should be interfered with at all. If it should stand, well, this complication would not arise. If, however, the court were to feel that that was more drastic than served the justice on the case, then the question, as I said, might arise in the form in which I have put it. And you wish, I don't know if you wish at any stage, or not necessarily now, but I thought that I should put that out for you so that you might consider it and deal with it if you choose.
Yes, my lord, I would wish to deal with it, and I had intended to deal with it when I came on to the issues of the exercise of discretion.
Do it at your time.
Yeah. Let me say that the passage to which I was referring as well about her making tape-in broadcasts is at page 223, the fourth affidavit, and it's paragraph, it has 4.10, but it's paragraph 54.10 on page 223. She said,
It's not a document in Schedule 1. It's not a document in Schedule 1
yes.
of her list.
It's not a document either in Schedule 1. That's the point I was going to make. In spite of the fact that the announcers play music primarily from vinyl records, CDs, cassettes, or reel-to-reel tapes in a live mode, I say that the defendant would or should have had log tapes as what was actually played. Further, the announcers in relation to the songs complained of did not only play the music, but the said songs were accompanied by commentary, sometimes derogatory of the plaintiffs, by the announcers, and it is therefore important to have the defendant's tapes of what was actually sung and what was actually said by way of commentary. For example, the defendant's broadcast on the 19th of July 1989, which I taped, contains the Mad Chicken song and Tit for Tat. The commentary is interspersed in the Mad Chicken song, and the volume of the song is lowered while the commentary is given. The commentary makes reference to McDonald Farms, the first plaintiff, in relation to a court case, and the possibility of the Mirchandanis, the first and second plaintiffs, taking the defendant to court. Immediately after the Mad Chicken song, Tit for Tat, is played, and these matters are material, especially in view of the fact that by paragraph 5 of the amended defense, the defendant denies that the words contained in the songs referred to or understood to refer to or capable of referring to the plaintiffs, the point which the President raised. But that document, I'm sorry I have to go on the Me Too argument, sir, but that document, likewise, is not disclosed in her affidavit of documents.
The broadcast of the 19th of July.
It's not disclosed in her affidavit as well.
Which she says she has in her possession.
And she says she has that in her possession. So that when I made this submission, I'm not being cagey or moving away from the point. The submission I made at my opening was absolutely clear that the standard of disclosure and the standard of the interlocutory matters that occurred in this case were not at all times in keeping with the rules. And it applied to both parties. And Miletta, although this by itself would not have been in itself a major point, the respondents make a lot of the fact that the first affidavit, a list of documents, the appellant reserved the right to file a further list. Now, if one goes to the plaintiff's list, and that's again at tab number 7, at page 43 of the record, there are two places in which a reservation is made. Page 43, number 3. The first plaintiff's financial statement, year ended the 31st of March, prepared by Mr. Merrill. The plaintiffs reserved the right to provide a further and better list with a financial report and other financial documents. And at the bottom of the list itself, the plaintiffs reserve the right to file a better and further list in documents insofar as the same may be necessary. So it's not only in relation to the damages that are in issue that the plaintiff herself reserves the right to file a further list. She is reserving the right to file a further list in relation to all documents, and that hasn't been altered. Now, again, I say to the court, there is a continuing obligation on all parties, right up to the trial of the action, to file a further list. But this has been one of the submissions made in order to show contumely and contumacious conduct on the part of the applicant. So that the court has to do a balancing act. And that balancing act, in my humble submission, was never performed, certainly by the court below, and I do not revert to issues in the court below unless your lordships want to hear me further on that. because, and secondly, the same balancing act was not performed by the Court of Appeal. If one stands back and looks at the system of disclosure by both parties and the manner in which it was done, then one would agree that it did not at all times, either of them, conform with the strict provisions set out in the rules.
But is the situation not rather different? First of all, an order has been made for a further and better list of documents. And then an order has been made that unless that further and better list is filed within a certain date, that the defense be struck out. And is it not different yet when there is, based on alleged non-compliance with that second order, there is an application to a further application to strike out? In other words, I'm saying that while there may be a certain laxity, regrettable though it be, initially in dealing with discovery, when you are under the gun, as it were, then it's time to adopt a more serious approach.
Yes, my lad, we should have shot likewise as fast in satellite litigation. Because the effect of that is, since we have not applied, then of course you cannot say that the plaintiff is in breach of an order. But the plaintiff is also in breach of a rule. So that the order has to be obeyed, but the rule can be breached without any consequences, although it is a rule of the court.
You see, I think, generally speaking, I don't know if it's true in Barbados. I suspect it is from what I've seen in this case. But there does tend to be a rather cavalier approach to discovery among attorneys. For instance, this is not a matter of any great moment, but in the defendant's initial list, where there is said to be no documents, none in the second schedule, strictly speaking, the letters which were written by David Simmons, that should have been categorized in Schedule 1 as copy of, and the original should have appeared in Schedule 2.
That I can confirm there is that laxity, and it persists.
Yes, but you see, that type of approach sometimes leads to a more serious lapses, which sometimes produces striking out your defense.
Yes, but I have the honor from time to time to appear in the Eastern Caribbean, and let me say that particularly under the new rules, the standard has risen considerably, and hopefully the new rules in Barbados would remove the sort of laxity that one sees in the practice. But I would be failing in my duty if I didn't say that that laxity persists until today in Barbados, and that's a fact.
You are not unique. I experience.
Yes. But so Millard, if one comes to the issue of the exercise of the court's discretion, we say, Millard, that both a balancing act and proportionality was called for in this case.
Do you have any authority which supports the application of the doctrine of proportionality in this context?
Yes, Millard. Some of the authorities
the Logic Rose case.
Logic Rose and B4.
We are bound authorities. Bring up.
Number 14. B4 is number 14 in your judge's folder of volume 1 of this volume, Miller.
Is it one of these?
This one. It's the green folder, Miller.
This one? Let's put on my criticism and mix them. 14? Yeah.
B4 against B4 and others. When considering the consequences of a party's failure to comply with an unless order, the court should, depending upon the circumstances of the case, bear in mind the balancing exercise required and the need for proportionality in respect of any sanction it intended to impose on the defaulting party. The Court of Appeal so held when allowing the appeal of the defendants, Mr. B4, Ms. Pamela Ray, and their son. Because of non-compliance of unless order as to specific discovery made by consent. And this was in relation to a consent order. And in that case, over the page, it refers, it says, having considered the issues raised by the pleadings and the history of the litigation to date, His Lordship said that the judge was right to conclude that the default was not actually contumacious and there was little, if any, force in the criticism that he treated high-tech systems and Coventry as imposing some relatively inflexible tests when in fact it did exactly the opposite. But there was some force in the criticism that the judge paid insufficient attention to the need for a balancing exercise or proportionality, the need for punishment to fit the crime as it was put in Joe K. and T. Holdings Limited. That's also repeated in T. Holdings Limited, in the Joe K. case on which my learned friends rely as well. And there are some other authorities as well. The principle of proportionality is well recognized as one of the issues to be considered. Now the other case that I think is, there are three other cases that I believe are helpful in the approach which this court should take to the matter, on the matter. One is the case of Real Credit Denmark. This is in the list, number 8 in the list.
Which list?
Green folder.
Green folder. Number 8?
Number, yes. Milletta, I wouldn't even attempt to read the whole of this case to this court. But in particular, I wish your lordships to look at the passages from paragraph 22, which goes about 5 pages. There's a pagination also on the side, page 5. If your lordship would just let me briefly refer to those 2 paragraphs. This court has recently considered the effect of failure to comply with unless orders in high-tech against Coventry City Council. Usually a failure to comply with such an order will result in the proceedings being struck out. It follows, I think, that before this drastic consequence is visited upon the offending party, the court must be sure that there has been a failure to comply with the order in question. The court must be sure. The onus is ordinarily on the party who alleges that there has been a failure to comply. Usually the discharge of this onus presents no problems, because in almost all cases the court is concerned with a total failure to comply. But this is not such a case. I think the right approach in a case such as this is to be found in two cases cited by Mr. Elliott. First, Abelian and Inus, which is also in our list. The dismissal of an action at an interlocutory stage is a very serious matter and may well work serious injustice. If an order is to be made in the form that unless one party or another does something, an action will be dismissed, it is imperative that the things to be done in order to avoid dismissal of the action should be specified in the clearest and most precise language, so that it may be possible for a party on whom the necessity of doing the act lies to be in no doubt whatsoever as to the steps which he is to take if he is to avoid his action being dismissed. Looking at it another way, where the defendant, in reliance on such an order, goes to the court and asks it to say that as a result of the order the action stands dismissed and it is not longer existent, he must be able to show first of all that the language of the order is sufficiently precise, and secondly, that which the order contemplates have occurred. There was nothing unclear about the order made in this case in that it required service of a list of documents. But a list was served, so prima facie the order was complied with. Interestingly enough, there is no reported case of an action being struck out as a result of a list being incomplete. But there is much in the litigated field of further and better particulars. Where in Reese and Wolf, the Court of Appeal approved the passage from the judgment of Justice Devlin, who said, so construed default refers to default in the delivery of a document within the specified time. I do not, of course, mean that any document with writing on it will do. It must be a document made in good faith and which can fairly be entitled to particulars. It must not be illusory. That is the test in my judgment, not as the plaintiff contends whether each demand for particulars has subsequently been met. But that I will read no further, but this judgment is worthy of reading. And that's why I said one of the issues I wasn't trying to delay the court was whether or not, given the pleadings and counsel thinking in the circumstances, well, let me see what you have. This is really not a tape, this is a record. And when the record is substituted, obviously that could not be an insignificant factor, as well as the fact that counsel did make some effort. Milord, I will be the first to say that there are cases which say that the mistake of the counsel cannot always be used as an excuse. But there are also cases which say, like in Pereira and Beanlands, that you have to take those circumstances into account. And
you say it was the counsel's mistake.
Well, the first mistake, and I'm not criticizing my own brother lawyers, so I do so with some hesitation, but the first mistake we made in this case is really not to have had in place counsel at the most critical times. And the most critical time here was the time when the plaintiffs, having filed their document late, applied immediately. Applied the sort as they're entitled to do to strike out for further and better lists. That was a very critical time for us. Now, the defendant was in a position, of course, that his main legal advisor was not available to it. The second critical time is it looks wrong for us to have an order of that sort made against us with us not appearing. We have sought to explain our non-appearance by the circumstances of what was happening to one of our counsel. The third critical time for us is that, as they were entitled to do, the respondents promptly applied for further and better lists or otherwise for us to be struck out. And the fourth critical factor at that time was that, unfortunately, Mr. Gollop, who is fast developing into be one of our good lawyers in the Caribbean, was green. And this is no criticism. I'm here before the court as a lawyer of some 40-odd years standing, and I have to be candid as I can with the court. The point is that this was litigation at a level in which it was obvious that the plaintiffs were going to pursue relentlessly and take advantage of every situation and opening, and which they did. And I'm not criticizing them for doing that. But these are matters that one has to use your president's word, to apply common sense. And that most of these situations occurred. And if one looks at the history of this matter, as is done in the other cases, the history shows that most of that litigation took place at a critical time.
The Fifth was not appealing against the order.
The Fifth is not appealing against the order.
But I don't know. I don't share your supreme confidence that that appeal would have won. But we're not going to argue with you.
No,
but I
I'm sure at the time.
Your point. I'm not prepared to say it wouldn't have, but I'm not as confident as you are.
Millett, I'm sure that if at that time your lordship, your honor was available, I would have rested my money on you in. But that's those circumstances.
Have you finished with Real Credit on paragraph 28?
Yes.
The first two sentences, are those relevant?
Applying the language of Wolf, of Reese and Wolf, I think the lenders list could fairly be described as a list. It was not illusory. It would still be a list even if a subsequent application for specific distillery had elicited further documents. Yes, we are relying on that as well, because early in my submissions I said that there were two alternatives available. One of the alternatives, one is, in fact, they're both still available, was to go for specific documents. And from early we argued both before the Court of Appeal and when we sought leave to appeal here, that really what was required was an application under 24/7. And in instances, particularly when you're going for classes of documents of this nature. And we also has submitted, in those circumstances, that some effort was made
Yes.
But the whole of that paragraph I would seek to rely on as well. So I think the judge was persuaded to adopt the wrong approach and apply the wrong test to the valuer's application to dismiss the claim, and therefore his decision cannot stand. This was not simply exercise of the judge's discretion. In my judgment, if he had approached the question, he had to decide the way I think he should have done. He would have decided that the lenders had complied with the unless order. Instead, he embarked upon a protracted and unfocused exercise, which ended up with insane in effect, that it was for the lenders to show that they had given proper discovery, and he did not accept the affidavit evidence that they had. It is possible also that he had misapprehended the concession which the lenders had made, since he referred several times in his judgment to the fact that they admitted that their list was incomplete. They had not done that. They merely admitted that the material which the valuers put before the court was sufficient to mount a specific application for an order under Order 24, Rule 7. There are other...
Taking you away from that to something... leaving aside any technical rule of concurrent findings, but the fact of the matter is that 7 judges in Barbados were of the view that either that the judgment should go against your client or that it should remain against your client. Ought we not to take some notice of that, really? I mean, is that something that we can't simply shut our eyes to?
Sorry, I missed the first part of it.
I said the fact of the matter is that 7 judges in Barbados are of the view that your judgment should go against your client because of your failure to comply. Now, as I said, leaving aside any technical rules about concurrent findings, isn't that a matter that we should take on board?
Yes, Milad, the fact that there has been an opportunity to present the case to 2 courts below is, of course, a factor that you would take into account as a final court in exercising your appellate jurisdiction. I wouldn't say otherwise to the court. But you also are confronted with the fact that they're really not concurrent findings of fact, and that the first trial was in itself really not a proper judicial determination. So that immediately undermines given any weight or any significant weight to the first trial before the judge below. In relation to the second trial, there was almost, other than on the issue of Order 24, Rule 3, whether it was an Order 24 or Rule 27 application, the Court of Appeal almost accepted the court below without any critical analysis of the reasoning and the judgment involved.
I don't know that that is fair, you know.
No,
the Court of Appeal, unlike the judge in first instance, did address the issue. Well, what are these documents which were not disclosed?
Yes, it did.
And they did make certain findings based on the evidence with regard to that.
Yes.
Some, I think, my memory, if my memory is correct, they found that 2 documents were really admitted to have existed. I think that would be the 2 that I directed you to this morning. The longer tapes, which were kept on a daily basis, and the computer tape, which appears to me to be of rather less significance. And then they did also go on to find, this is more controversial, certain facts with regard to the existence of documents, or the one-time existence of documents, contrary to the evidence of finance. In other words, they said that finance really could not be believed on that.
Yes, Milad.
Am I correct?
Yes, Milad. No, yes, Milad. I'd only made the first part of my submission because they did make some findings, and that's referred in paragraph 21 of the skeleton arguments. They did make some findings in the judgment at paragraphs 18 through 24, with which we take issue. But, and your Lordship, your Honor has been directing me to some of those matters earlier,
yes.
And we weren't exactly at them, all of them, but I hope I have persuaded you otherwise. But so I wasn't criticizing the Court of Appeal in relation to its function on that part of the case. I was criticizing and not meaning this in a destructive way, that in looking at the judgment below, the only matter they seem to have considered is to say that, yes, he didn't consider whether it was under 24 or 24.3 or 7, but we say it's 24.3. And then he finally added up saying he came to the right conclusion because of all findings at paragraph 18 through 24. So that seemed to be the approach of the Court of Appeal on the matter. But the Court of Appeal itself did not look at other matters that it had to take into account. And those matters related to the...
Were they entitled to disbelieve without his being cross-examined?
That too I have addressed in my submissions.
Yeah.
One of the critical things is that there were vast differences on major and minor matters relating to the disclosure procedure and other facts. The instance, for instance, Mr. Dewsbury. And Mr. Dewsbury is very critical in relation to Mrs. Mirchandani's statement that she says that there was a master tape, that he had shown her a master tape. But Mr. Dewsbury had died by then. Now that was an issue that could have been explored, but there was no cross-examination in this case, and I've referred to the principle as set out. I've referred to the principle as set out in the rule, well-known rule in Brown and Dunn, and that is at page 18 of my written skeleton arguments. So, in those circumstances, there is another approach that has been taken in similar circumstances. In the case like Lonro and Faid number 3, which again I believe I have referred to in my skeleton arguments and in the record, where those matters can be canvassed at the trial. And in fact also in Cephas Shipping Corporation and the Guardian Royal Exchange, which is Lonro is in the bundle is number 29 in your judge's bundle of volume 1, number 9 in volume 1. And Cephas is in volume 3 of your judge's folder. Volume 2, number 4. Volume 2, number 4.
But I read this last night.
This morning.
You have it there? Cephas. The relevant pages of Cephas is number 4, but it's only towards the end of the judgment that the whole issue of discovery is dealt with. It's if one has the report at the top, it's page 25 at the right hand side. There are 26 or 32 pages, and it's page 25. And the whole issue of discovery.
Yeah.
It's 25.
It's actually 26 of 32, but then below it's headed page 25.
Yes. The discovery starts at page 25. And it's
Page 25.
And it reviews the cases. But Cephas was an unusual case because the actual hearing took place and the plaintiff's action was actually dismissed. And during the trial, the issue of discovery, whether or not proper discovery had been made, was still pursued. And therefore the judge ruled on that issue and said, look, the plaintiff had no difficulty in proving the case, so that there's no point in making an order under Order 24, Rule 16. But it did set out some of the principles that apply, and one of the things it says clearly is that I do not think a claim or defense can be struck out except on clear and uncontested evidence, either as a result of an admitted breach or because the breach can be ascertained from the parties' own documents, affidavits, or pleadings. That is at page 30 of the record. But I will ask your lordships to read the matters, because it reviews the Landrow case. It also reviews the case which my learned friends are relying on, of Landauer's case. And it's a 1995 decision. And one of the passages that I draw your lordship's attention to is the bottom of what is the top is page 29. From the reasons for the rule that the statement in the affidavit of documents is conclusive, save to the extent that a further affidavit may be ordered, are not far to seek. As long ago as Morby and Bewick No. 2, 1856, which was a case on the Chancery Procedure Act, Section 40, where the court held that there could not be cross-examination on the affidavit of documents, Lord Turner said that both justice and convenience required the construction put upon the section by the court. In the great majority of cases where it is alleged that one party or other has suppressed documents, this issue will be crucially relevant to the issues in the trial and can only properly be determined after the judge has heard all the evidence. To try the issue at an interlocutory stage could involve injustice to both parties. Assume it is the defendant who is alleged to have suppressed documents. The judge might believe the defendant despite the cross-examination. That would be an injustice to the plaintiff who had not deployed all his evidence. If the judge disbelieved the defendant simply on the cross-examination, that could be an injustice to the defendant because there might be other evidence which he could call which might persuade the judge he was telling the truth, or at least leave the matter in doubt, so that the plaintiff would not have discharged the burden of proof. Mr. Falk says here there is nothing to prevent the defendants calling other evidence at the interlocutory stage. I do not agree. That is not what the judge has ordered. He's only ordered cross-examination of the deponents. Such a procedure would subvert the normal method of trial. The defendants would be subjected to an inquisitorial inquiry without having the advantage of hearing first the plaintiff's case and their own evidence, a judge in chief. So that although he differed in some respects from Lonro, the position is that it is protecting almost the conclusiveness of the affidavits. And this case, with respect, I say, is unusual in many ways. Because what I understand your lordships, your honors are being asked to say is that Chief Justice Williams may have intended and may have supposed that this was what is intended by the order. And
let's not go back there.
No, I'm not going back that far, but I'm saying that in instances of this nature, particularly where the allegation is suppression of a document, falsity, lack of credibility, and disbelief.
I think here it's not so much a suppression of it, because ultimately, at least in relation to two documents which he admitted having once had, there was to that extent no suppression. But I think that the fact that those admissions were only really almost wrung out of him as a result of the barrage of affidavits and the threat of having his defense or the defendant's defense knocked out. Amounts, it is said, it would certainly amount to non-compliance. If the interpretation which I was putting to you of the affidavit is the correct one, in terms of its admissions, the question of how contumacious it was and how serious it is and so on, and what sanction it would justify is another matter. I don't know if there are degrees of contumaciousness, but I think that there may be a certain danger in limiting one's inquiry to whether A, there was non-compliance, and B, whether there was some extraneous circumstance which prevented compliance. I think that might be too narrow an approach. Do you suggest so?
Yes, my lord, and we have tried to address that issue in the throughout the submissions, but particularly in the paragraphs from 24 onwards.
I'm grateful.
Yes.
So I think that the other criticism which may be made of the conduct of the defendant is that while it is true that this action was not launched until when, the end of 1990. As early as around the 11th of July, they were aware that the plaintiffs were complaining about they're playing these three calypsos. And there was not an explicit, but a very strongly implied threat of legal action in the letter which was written by the plaintiff's lawyers, which received a robust response from Mr. Simmons. But I think that the criticism would be that with knowledge of that, and no doubt they must have known of the other action brought by the plaintiffs in relation to the same songs. I think that the ground of criticism would be that they should have preserved those master tapes.
Yes, the letters to which your lordship, your honor refers, was written on two letters written on the 11th of July and the 13th of July.
Yes, two had the same terms, right?
Yes, one spoke to the Mad Chicken song, and the other spoke again to that Mad Chicken song. They both spoke to the same song and asked for an apology. It was the standard.
Invited them to make an offer of damages.
Yes.
And indemnity of costs.
Yes. There was a reply.
Yes, a robust one. I described it as.
Yes.
Like something like go fly a kite, really.
Well, I don't think he got into kite flying yet, but there was a genuine disagreement.
I'm not no disrespect to the letter or the writer.
Yes, there was a genuine disagreement as to whether the matter complained of constituted a libel or not.
Yes.
And the only matter I would say on the letters is that in that letter, we are told that proceedings have already been filed in relation to the defamatory material in respect of the Dead Chicken song.
I requested to have to write not my stance, but a little bit continues to press on that. In fact, there were several actions, certainly a few actions against the nation, against the advocate, prior to that.
Yes, yes.
So that's not fair to my learned friend. He feels a few pieces, being unfair. First of all, the passage is worded as not quoted actions. And he does not say so that they were filed against the refusal. So they're being filed. They were filed against other broadcasters.
Yes, all right. I think we are aware of that.
I'm not going to pursue matters that are in dispute,
Yes.
because the information that I have is that certainly no proceedings was filed against this company.
Oh, no, not against your
And
company.
secondly, that no other proceedings, whether it's right or not, my instructions, and I haven't checked it myself, is that no proceedings had been filed. But
I don't think that
but
anything
I don't think it's a major
turns on it. The point
Right.
is, Sir Henry, which I was drawing to your attention, is that there was a real possibility known to the defendant at that time of litigation against it in relation to the playing of these three calypsos. And in those circumstances, it behoved the defendant to keep those tapes.
Yes, my the defendant has said that at all times he relied on advice received. It relied on advice received. Maybe the wrong advice, but it relied on that.
Well, we have no reason to believe that the
Yes.
advice was wrong.
Yes, there is, at that stage, there would have been the normal practice among the profession is for you to advise that discovery may become an issue. I'm not arguing against that. I'm not sure that in relation to the events that the documents themselves, that there was a duty on the defendant, but the defendant should have been warned. But that's as far as I will go, my lord, in relation to that particular issue.
Yeah. Anything else, Henry?
My lord, I think I would just want to possibly end my submissions with the view that I have expressed previously. That a lot of the cases dealing with striking out in these circumstances are becoming irrelevant in the new regime that exists, because there is much more disclosure in many respects by way of statements, witness statements, and the case management control system ensures that some of the laxity to which you have referred no longer will take place within our jurisdictions. But in this case, it seems to me, Miller, that the balancing act of which I have addressed on which I addressed the court, and which is referred to in my submissions, is very much required in a case of this nature. And proportionality is also required in a case of this nature. Because ultimately the question is a fair trial still possible? Even in cases of contemnors, that question is sometimes asked. And in the case, given the features of which I have outlined on the parts of both sides in this case, given the fact that the plaintiffs' respondents admit that they have documents relating to the matters of their complaint, the only document date on which there is not an admission in relation to is in relation to the finals. But then again, that the finals seem to have been taped in a homemade, not in her list of documents. There's not an admission as to the finals. But if one goes to the, and my learned friend has just mentioned other cases, the CBC case, in the report itself, which has been cited in the bundle, then the plaintiff also has a homemade recording of the live broadcast so far as the songs were played, which took place at the stadium. On August the 4th. And that is referred, well, let me look at the CBC case. I think my learned friends are shaking their heads, and I don't want to mislead the court.
But of course, if you contumaciously disobey an order of the court, is it open to you to say, well, you know, it really won't affect the outcome of the case?
Well, it is open, because the court also bears in mind that it wants to see justice done as a whole. And if a person can be, both parties can have justice, even if there's a sanction for disobeying a peremptory order, then that sanction need not be by way of striking out. And that's what I'm trying to get over to your Lordship.
The whole point of the striking out was not something, was to punish the party in default.
Yes.
And to encourage the others not to follow suit, to obey orders of the court.
Yes, but
that was the rationale for it.
A lot of that rationale has been modified in light of the developments that have taken place subsequent to some of the older cases. As you would be aware, very much aware, there's been developing jurisprudence on the matter. But, my lord, on the CBC matter, I would just refer your lordships to the bundle, Volume 1 of the Judge's Bundle. In that case...
What case is that?
CBC, tab 13, Caribbean Broadcasting Corporation against Asha Mirchandani. Page 4 of the judgment. Page 3 is the first part. Here, for the first time, is an unequivocal denial that CBC ever made or had in its possession, custody, or power of videotape of what it had broadcast over television from the stadium on the night of the Picardy Crop Finals on the 28th July 1989. That's what this is. It's in direct contrast with the letters from CBC's attorney at law. And I'm reading from the report. The respondents have a poor quality home recorded tape. That's on page 4. But they seem to speak of the 28th of July as the finals.
Not a lawyer's mistake, sadly.
Well,
they seem to follow you around.
But that in this case, it may
yours,
be,
of course,
it may
you have to clean them up.
It may be the court's. Well, that's the judgment I was reading from, not mine. Well, that's. We're still trying for the perfect world. Well, unless there's any other matter on which my assistance is required. Meletta, I've already drawn it to your attention, but my instructing lawyers believe I should ask again that your lordships read the Cephas judgment. This one?
Yes, we look at them.
Yeah. And particularly from pages 28 to page 30. Matching that is.
Thank you. Well, it is now 1:15, and we will take the luncheon break now and resume at 2:15.
Come along and get ready for whoever's going to see them. Yes, well, there wasn't much time if one was not prepared. Yeah. Give that a while.
Your Honours, I apologize for lateness of this. My friend got trailing.
Yes.
I was faster than them on my feet.
I think it's only...
Please forgive us, sir.
We did get a taxi, but it looked as though we didn't do any better with the taxi. We thought it was too hot to walk. We'd be too hot and sweaty by the time we get here, but taxi didn't do any better, sir.
The main thing is you are here now.
Yes,
so
thanks very much, sir.
Shall we?
And someone is bringing my bag and my notes.
I'd just like to place on record, ask for, let me place on record my misstatement, in which I said proceedings have not been begun. I'm informed now, and I replied that Mr. Lassie has commenced proceedings in matter. So I wish to apologize to the court.
Thank you, Sir Henry. Thank you.
Yes, that was explained to me when we drove. I pointed up to the other side of the city, had it got to the fall.
Yes.
So I'm seeing a lot of bags being brought in, but I'm not seeing mine, sir.
Well, I hope it hasn't been impounded.
No, I don't.
What used to be here.
I think it's here now, sir. I think over time, so you're going to, if not immediately, so you're going to need a larger podium, sir.
Well, I hope we get a larger room to start with.
Yes. We've spent a lot of time this morning, sir, covering useful ground in terms of revisiting the orders, looking in detail at affidavits, and even reviewing in some details some relevant cases. And to that extent, I believe that the way has been cleared for me to join issues straight away with my learned friend, and not to be too bogged down with the on-appeal orders and the unresisted affidavits of Mrs. Ram, because I think so that there are concluded implications that flow from them which the court has got to address. But before I get there, sir, let me begin where my learned friend began and deal first of all with what he claims for the first time now to be a deficiency on our part, in that our pleadings speak of recorded calypsos and not of the live broadcasts. Well, there are several answers to that. One is that in the pleadings is set out in great detail the words used in the live broadcast of both the semi-finals and the finals. Secondly, over the last 13 years or thereabout, from 1992 until present, when these interlocutory proceedings have been underway, it was common ground, sir, never challenged, that what we are talking about is not only the records played for periods in August 1989 down to some period in 1991, but also the live broadcast of the pick of the crop finals of the 28th of July 1989 and the finals of the 4th of August 1989. So coming at this stage, after 13 years of interlocutory proceedings, when all the courts have implicitly and explicitly proceeded on the premise, on the assumption that the discovery of which we have been complaining relates to the live broadcast, is not only to come too late in the day with that, sir, but to miss the point, if I may be permitted to say that the affidavit of Mrs. Ram of the 12th of October 1994 sets out in great detail paragraphs 3.32 to 3.35 what it is that is missing. That affidavit has not been challenged. It was never resisted. And it led to certain concluded inferences and implications that they had more to give which they did not give.
Well, it wasn't challenged at the time, but the subsequent affidavit sworn by Victor Fernandez I did challenge at least parts of it.
That is correct, sir, but the question will arise there as to whether or not that affidavit did not come far too late. Remember that the order of the 20th of February, the Chief Justice's order, where he not only repeated the earlier order, but he guarded it with an unless provision. That order said that if by the 6th of March there was not compliance with the order, both of November 24th and of February, which was the same order, then a certain consequence followed. The defense would be struck out. And at no time prior to the 6th of March did he put in that sort of affidavit. He put it in November 1985. And the question is, what is the status of it then? Ever since the 6th of March, once husbands found that there was non-compliance...
Justice husbands.
Justice husbands, I'm sorry, sir. Once husbands found, justice husbands found, sir, that the discovery, the list filed on the 1st of March was not compliant, which was an implicit finding that he made, not an explicit one, an implicit one, clearly implicit. It followed that, except for determining the question of whether the conduct was contumacious or otherwise, he in a sense had little choice. He in a sense had little choice but to follow that order, since it was not an appeal order. And that's one of the implications of the order being not an appeal order. He had to follow it once he found that it was not compliant, which was a finding of his and a finding of the Court of Appeal, and once he found too that the conduct in all the circumstances was contumacious conduct.
Yes, but couldn't the affidavit of Mr. Fernandez be taken as going towards the issue of the contumacious nature of the default?
The question is whether it was not an affidavit that came too late, and what was its status. It seemed to me that it was in effect no more than an attempt to resist the full impact of the hammer that arguably had fallen. It was virtually to a plea of mitigation.
Is it that you're saying that once the period of time within which the further and better list should have been filed had expired, that the judge had no option whatsoever but to strike out the defense?
I wouldn't go that far, sir. I think I wouldn't be supported by legal principle. He had to satisfy himself, one, that the list of the 1st of March 1995, which we all agree was just a repeat of the old list, except for was a worse list actually, because arguably a tape, we were now told, didn't exist, only a record. So it was arguably a worse list. And once he found one that discovery, that list did not constitute compliance. And once he found that the behavior was contumelious and that there were no external factors outside of the control of the defendant appellant, which would explain the conduct. In all these circumstances, it is hard to fault the consequences that followed.
Don't you think that the order could have been more specific? That it should have enumerated exactly what was required.
And that's my second point, and thanks for bringing me onto it, is we want to move, and I appreciate the questioning. The general principle, which has been emerging in recent years, and it's a principle almost of logic, that if you say that a party has not complied with an order, it should be clear what that order is, and that has become a kind of general principle in recent cases. But in this case,
a very old principle, Dr.
yeah, well, perhaps revive and restate it. Yes, but I would say that it would not have application in all circumstances. In this case, there was never any doubt resulting from the pleadings, statement of claim and defense, resulting from the affidavit of Mrs. Ram Mirchandani. What were the items disclosable that were not disclosed? And if indeed the defendant appellant had any difficulty arising by way of vagueness and uncertainty, they had a responsibility to go back to the court. But to come now, after these many years, and say, and raise for the first time the point about vagueness and uncertainty, is really to make a mockery of the whole exercise. The courts were always open. And if indeed that was a genuine problem that they had, it should have surfaced before now. And they always had the opportunity to go back to the court. So I would ask that an exception be made in this case to that general principle.
But I don't think there is any doubt about the relevance of the documents which were not disclosed in Schedule 2. So the question of uncertainty would appear not to arise.
Well, it has surfaced today. It has surfaced at this stage after these many years, and I would urge that it was known to all parties. Certainly no one ever said.
The order was required that they disclose all relevant documents that were or had been in their possession. And the documents which it emerges from the affidavits of Mr. Finance were in their possession were clearly relevant. The master tape was clearly relevant, which is the principal document that was not disclosed.
That is correct.
So I'm not sure how the question of uncertainty comes into it by itself.
But that seems to be the gist of what my learned friends were saying, that there should be spelled out. The discoverable documents about which you complain should be spelled out with such certainty that at the end of the day, if you didn't comply, it could be said, well, there were A squared, B plus, C minus.
But that's what you are saying. You are saying all of that is discernible from the documents that preceded the order.
That is what I'm saying, that it was clear.
What they are saying is you must have it in the four corners of the order.
Well, that's... Sorry, sir.
Isn't that what they're saying? I mean...
Yeah, but is that not a theoretical point in the events that happened?
Well, they say that your point is theoretical. Because why should I get out of the box of the order to find out what I have to do? You say no.
It was a general order. It was not under Rule 3 and not a specific order under Rule 7. It was clear from Mrs. Ram's affidavit, which they had never resisted in any way, what the documents were. It was clear from the pleadings too. And for them to come years after trifling with the court, engaging its integrity, this is very important. That's what they were doing. Being dodgy. That's what they were doing. And it was a very serious thing, because the whole question of whether the behavior was contumacious or not is not only a question in the end as to whether there can be a fair trial, because that is not an index of contumacious behavior. The broader administration of justice was engaged. You're making orders all the time. People are ignoring you, doing as they like. pure silence. Now coming with excuses involving the name of my learned friend, now Chief Judge. He was sworn in days before I was sworn in. We all knew of our obligations. We were both busy attorneys. Pressing important cases, we call up the clients and said, look, you're aware of the fact that we are now in ministerial office. Do you want me to find counsel, or do you wish me to hand back the file to you? But months after, Barbados is not short of lawyers, they're in the hundreds. And now they're saying that because he went to office in 1994, the 7th of September, it followed then that the absence of representation on the case until the following year is to be excused. I believe the high-tech case in the third paragraph has something about that to say, and we'll get to it. But all of these are matters that are surfacing now. And we have to ask ourselves whether they are genuine or they're just theoretical points that has no relevance, by the way, to the exercise of the discussion. And all they're doing is making the former lead counsel in the matter look as though he was irresponsible. He did not pay any regard to his client's interests. And in the language of the street, I would say, don't go there. Leave out that. Leave out that. Doesn't make sense.
Dr. Sheldon, if Mr. Fernandez's affidavit is to be believed, would it be correct to say that the documents which should have been included in the list but were not, or the statements which should have been included in the list but were not, would have been that we may have had lock tapes, but we no longer have them because of A, B, C, D, or we did have them, but we no longer have them because they are recycled. We may have had the semifinals and or the finals, but we no longer have them because they would have been recycled as tapes. Would that be correct?
That is true, but Mr. Fernandez's affidavit must be seen for what it is. It needed no cross-examination. On the face of it, he condemned himself, or the principle for which he acted, rediffusion. Because he admitted, one, that he had material which was disclosable. And if we look at the last paragraph, I have it in a minute, where he said that tapes or material was available up to 3 years after, long after proceedings had commenced. Long after proceedings had commenced, tapes were available. I'll get that particular quote for you. Something was available, discoverable material, and yet it was never disclosed. Which meant that in failing, therefore, to disclose in Schedule B of the two lists that he provided, those discoveries were not true discoveries within the meaning of the order.
Let us get what it is, and was kept for 3 years.
Yes, it is at page 219. It is at page 219 of the record.
That's his second affidavit, I think it is.
Yes, that's right.
And this is what he's saying, sir.
Yes.
This is very important. The defendant has no log for June, July 1989 in its possession. Page 219, sir. These logs are usually kept tab 31. Tab 31, page 219 of the record, sir.
Yeah. 29th of January 96. 31st January 96.
The affidavit one is at the 9th of January.
Yeah, there's actually 5 on it.
Oh. What paragraph is this?
And this is the supplemental affidavit of Victor Anthony Fernandez, dated the 31st of January 1996. Page 219, sir. He says the defendant has no log for June, July 1989 in its possession. These logs are usually kept for 3 years pending completion of the annual audit of the defendant company. Once all queries in respect of these logs are satisfactorily answered, then they are destroyed.
Yes, but the logs which we're talking about here are not the same as the log tapes. These are the logs which are merely the printed record of the day's programming, which doesn't contain any indication of what music was played. Well, it certainly doesn't identify the songs or the tunes played.
But in another aspect of the earlier affidavit of November.
If I may suggest, yes. I think it's
the November.
I think the relevant documents are the long tapes. And we've had a lot of exchange this morning with Sir Henry on that. But they, as I recall, are kept normally for 3 months, I think, or less.
2 months.
Normally.
Paragraph 31, sir, of our skeletal deals at length, sir, with pages 12 to 14. Deals, sir, with the aspect of the logs and the tapes. And we are contending, sir, 34.3, page 13, that from the appellant's own evidence, there must have been log or master tapes revealing when and how often the offending calypsos were played. This would have included log tapes for the occasion right up to July 91, when Pluckett was played on Yes FM 10.4.
But would the logs for Yes FM or the log tapes for Yes FM be relevant to the complaint here about broadcasting over VOB? You're saying I'm being insulted by what, or the plaintiffs are saying I'm being defamed by what came over VOB. How does the Yes FM assist us on that?
Well, that's the daughter. Rediffusion is the mother.
He's seeking to visit the sins of the mother on the Lord.
Yes, he's seeking to visit the sins of the mother. But a letter was written dated the 4th of July, 1991.
Dr. Chalter, they are long tapes. Well, that is to say, they are master tape. They were kept off, according to Mr. Fernandez.
Yes.
They were made and kept off Voice of Barbados. I don't think there is any indication that they were kept off the other station, the FM station. The tape that they had on the FM was the one that was made, they say, from the vinyl records and was used for the computer, the automated operation. And it would not be of any great use to the
trial,
to the plaintiffs, or not as much use at any rate as the master tapes of the relevant days.
That is correct, sir, but when it is borne in mind that as early as 89, just about the same period, they were put on notice that we have serious concerns. We have quarrel with this defamatory material that you have been broadcasting, with the indication that writs have already been filed in relation to some of the other stations. It seemed to me that they reasonably ought to have made sure that they secured their material. I think that today, and I'm not...
Fairness to them, you see, Henry says we have to look at both sides. When Mr. David Simmons wrote and said that the song had been excised from the computer tape, there was not a letter written back in horror saying, how could you do that? You must preserve that.
The horror is fresh till this hour.
What's that?
The horror is fresh until this hour. And one thing that at least is this, sir.
What does that mean?
That this court, sir, should find it necessary, in the light of all that has happened, to make a statement about the obligation and the responsibility of counsel in matters of this sort. Because the letter, as I read it, almost boastfully says, and they were excised on my instructions.
What does that have to do
But
with
that is in order to prevent it being played again.
No, that is to make sure that this court, or any court, will never be able to hear it.
I think that's
but
not fair.
how is it relevant to this statement of claim?
Because it was material that cast light on the issues that were in dispute.
You mean in relation
And
to the SFM?
yes, and they told him that he was written to, and the station was written to and told that that issue of their continuing to play that for a year and a half and more after the pick of the crop finals, the Calypso season, went to exaggeration of the damages.
Yeah, but remember we're dealing with the statement of claim and discovery.
Yes.
So you're dealing with the issues that arise out of the statement of claim.
Yes.
Now,
But that is not the only document that determines relevance.
I think it might be relevant. You see, there's apart from a reference to the party to be accepted as the same so just being played on that was the one that we complained about. When they complained about that, they didn't say, oh, look, this is I'm going to do it with you. So they accepted that it was reference to that. Also it was not just on the question of when it should have been disclosed.
yes.
I think that this one is very more technical. What station of the car? Yes, Dr. Sheldon.
Yes. I was making the point, sir, before the dialogue encountered, that Fernand's affidavit demonstrated quite clearly that Williams's second order for further and better lists, that his reasonable suspicion was justified. There's no question about that, because he admits that he had material which was discoverable, which was not discovered. It confirms too that Mrs. Ram's unresisted allegation, particularly in the affidavit of the 12th of October, that they were well grounded. And it meant further, sir, that the discovery in relation to the first list and the second list, that there were not true discoveries within the meaning of the order. Now that's a very serious thing, sir. And the question would arise that among other factors will lead to the question of what was the just penalty, and that is what I understand disproportionality to mean one of the cases this morning referred to it as making sure that the penalty fit the crime. That is what proportionality means in some contexts, and that is how I understand it in this context. My learned friend was happy to repeat it ad nauseam without saying what is its practical effect and application in this case. What does it mean? I understand it, and I'm urging that it should mean let the penalty fit the crime. And I will argue later, and hint now, sir, that it was a serious crime, because when you come to the matter of contumacious conduct, sir, interests well beyond the parties are involved, the whole administration of justice. A court will be held in disrespect if every day it makes an order. If I say, don't mind them, man. Don't mind them.
But have we got any such evidence? They said don't mind them.
But their behavior was tantamount to that.
They were out of what?
When the court asked for further and better lists, so you gave the same list, and at one point the same list minus. You are not really taking the court seriously. The court says give a further and better list, so you give the same list minus. So what are you saying to the court? What are you saying to the court? You're not turning up. You're not either putting in an appeal or trying to use Order 24, Rule 17 for a revocation. You are ignoring the whole system, the whole process. And my learned friend says so that we ought to be guided by the more modern cases in the context of new rules in many Commonwealth jurisdictions where the court manages the process. But the reality is that this is under the old system where the lawyers manage the process, and so that the old cases got to apply. This is a case under the old regime.
Dr. Shelton, if the punishment must fit the crime, what exactly is the crime? Don't we have here a situation where there is no objective standard of the precise crime? That the plaintiffs are saying the crime is one thing, and that the defendants, by Mr. Fernandez's affidavits, we have to take those affidavits as true if we want to look at their situation, look at it from their situation, and therefore the crime is in failing to provide information that simply would have said, we had this, but we no longer have it because it has been destroyed. So that is one crime, in failing to say, we had this, but we no longer have it. And from your standpoint, the crime is in failing to say that you have X, Y, Z, which we know that you have. Which standard are we to take in determining whether the penalty is appropriate?
Following on from what my learned brother said, it will depend on whether the crime is a felony or a misdemeanor.
Yes, and you appreciate that from my submission, sir, I am viewing it as a felony.
Capital.
But I think that you have partly, Your Honor, Justice Saunders, come to the analysis that you have arrived at because you have ignored the fact. You said you must take Fernandez's affidavit as true, but the Court of Appeal didn't think it was true. It was clear that coming when it did, and given its contradictions, its evasions, that arguably husbands did not think it was true either. And to that extent, it will be hard now to accept that it is a truthful affidavit. When critically analyzed, it really attempted to exculpate Rediffusion while at the same time condemning them out of the mouth of their officer of finance. No question about that. And look at another aspect too, sir, where he could attract no credence. He says in relation to the substitution in one list, the second list of March 1st, that we said we had a tape in November when the first list was given, but now in relation to tit for tat, we only have a record. And he said that is either error or inadvertence. As much as take whichever one you like.
Did he explain the error?
No, he said it was either error or inadvertence, which in effect saying take whatever you like. You call it whatever you like. He had a duty, it seems to me, to explain the circumstances in which a tape was computed for a record. And why is it that that mistake came about? And he says it's either error or inadvertence. Mr. Sailor, take it as you like. That is dealt with, sir, at paragraph 46, page 16 of the written submissions.
Yes, Dr. Cheltenham, just getting back to trying to identify the crime that my brother Justice Saunders was trying to ascertain. Would the crime, from your viewpoint, be playing fast and loose with the court and with the defendants so as to spin things out? Are you saying that the defendants were pretending not to know what the court order was all about? That in the real world, no reasonable lawyer could possibly not know that it was the 5 points in Mrs. Mirchandani's affidavit that the court was basing its order on, when that was the only document referred to in the order, and that was a deliberate misconstruction of it as just being general. They didn't know what was going on, so they could spin things out.
All of that and more. And we are hearing about it now. But apart from that, the playing fast and loose with the court, trifling with the court, what Rediffusion did is really engage in a kind of frontal way the integrity of the court system. We are not respecting the orders. We are not taking you seriously. They had several opportunities to come clean. This is being suggested by the learned president. Several opportunities to come clean and said, look, we are sorry, but we did have material for one reason or another, whatever reason they gave. We didn't disclose it. We now wish to do so. We are prepared to meet the cost of these proceedings so far. We are prepared to accept a short time frame to put things right. But we need to tell you as early as now, the second order, the third, that we had material which we did not disclose.
Isn't that, in effect, the position of the Fernandez affidavits that they're saying? I mean, if you believe that there were master tapes, they're now said, well, we had a master tape, we don't have it anymore. I mean, they have come to the court and said that.
But should that not have come before March 6th?
Should have.
That's what the Chief Justice said. If not by that, you have to strike. And clearly it was not automatic, because they had to find non-compliance, they had to find contumacious behavior, they had to find that there were no extraneous factors and so on. But it should have come before his order took effect.
It ought to have been included in the Schedule 2. Yes. Instead of saying none alone, bluntly,
yes.
Ought to have explained that I had it, but I do not now have it.
But would that have advanced the case on the statement of claim any better had they come earlier and said, look here, well, we had this, we don't have it?
Well, for one, it is possible that we would already have been at trial. But after 16 years, we are still in interlocutory proceedings, and we have not got anywhere near, and I have no hope that we are going to get anywhere near in a hurry, because it looks as though with a trial by jury, and this has implications for whether there can be a fair trial too, with a trial by jury and 3 months or so indicated as the time that the trial will take. In courts that work from 9:30 to 1 o'clock.
3 months.
I'm sorry?
My letter doesn't hyperbole. The truth is that the time that has been forward by both
That's what I thought.
Nobody now believes that, sir. Coming to this case, and I've asked realistically, and I'm told that that's not now on. It's clearly not on. The smallest case in Barbados in the court system that work from 9:30 to 1 with a 20-minute break in between, and often have other competing matters keeping you waiting, so you don't achieve anything. This case cannot be done in any 10 days. Do not let us delude ourselves. But given the pressure on the court system, so with continuous exercises and family law matters eating up half of the time and crime the other half, sir, civil work in Barbados is attracting no attention in the court system.
But can we leave that for another time?
Yes, sir.
A joint application could be made to the Chief Justice to have it expedited.
All of that is being done.
This particular matter.
All of that is being done. I hope that very firm words will be spoken, sir. The court did ask this morning whether or not we are likely to have any difficulties in relation to this recorded Calypso issue. For example, a court may very well say, look, to the extent that no one is disadvantaged, this is only a pleading point that is being taken. You amend the pleadings and bring it in harmony with the interlocutory proceedings and what has been identified there as the discoverable issues. And
I would have thought that you would have taken in front and applied for an amendment.
So I have recently come on board in this matter.
Yes, well.
Very recently come on board in this matter, sir. But I have already indicated that it may be necessary, sir. But it may not be straightforward.
What I have been hinting to you is that insofar as we can, we will do everything that if this case goes back for trial, that we streamline it, and we get rid of any excess issues or any sort of matters that have to be dealt with that might cause delay. And if we have power to do it, then we are quite prepared and persuaded to do it.
Well, should that be the route that we are heading, sir, after reflection by this court, sir, then those guidelines may be necessary, sir.
We can't do it except on the initiative of counsel. And let us proceed now.
But you can be assured, sir, that those initiatives will be taken, sir, if necessary. I just wanted, before I go on, sir, to make the point that this was a discovery process of a general nature and not a specific nature. And this leads to the conclusivity point which was urged on the court by my learned friend. As I understand the learning in this area, the general principle is that affidavits verifying lists are conclusive, provided. And that only applies to begin with to specific lists, not general lists. The conclusivity point in relation to affidavits is not relevant in relation to general discovery.
Oh, is that right?
But that is as I understand the learning in Hayek and Matthews.
Well, Johnson, what is that? Matthews and what?
Hayek, discovery.
Well, perhaps,
insofar as...
Perhaps you should refer to the passage.
Yes. I've asked my learned friend just to see whether his extracts cover that. The second point, sir, is that in terms of general discovery, when once you have applied for further and better lists, the conclusivity point, sir, has no relevance. When once you have applied for a further and better list in general discovery. And that is what was done.
I don't know. I mean, I don't know. Is that so? Again, if you have authority, I would ask you to produce it.
Yes.
But again, take for example the
And Crane and Tracy, sir.
Take the go back to the financial statements, the balance sheet. If on the basis that you have disclosed the balance sheet but no supporting documents, listening to me?
Yes, I was listening, sir. The core point you were making, sir. Yes, sir.
Yes, if you disclose the balance sheet but no supporting documents, and an order is made for further and better discovery, and you come then an affidavit and you say, look, these are, and you give some excuse that the documents were lost destroyed in a fire, and will be open to the other side to seek to invite the court to disbelieve your affidavit?
Not in a circumstance perhaps like that, unless the affidavit itself attracts such reasonable suspicion or is so contradictory that it is clear that there are other documents that have not been disclosed.
But you put that, you say that of Mr. Fernandez's affidavit?
It so happened fortuitously, sir, that what we have found out since Fernandez's affidavits of 95, is that the court was fully justified in asking for further and better particulars. That is what is confirmed, and that Mrs. Ram's affidavits, the allegations made, particularly the one of the 12th of October, that they were well grounded. So it happens in this case that
I'm not quite following you. What I understand to be the effect of Fernandez's affidavit, accepting it at its face value, is that the first respondent was correct to a limited extent in suggesting that there were, or there would have been, some record of what was broadcast on the station, but that the records which did exist were not as extensive as she claimed, and that such as they were, they had all been destroyed or recycled. Isn't that the effect of Fernandez's affidavits?
So, but the court has to act at the time. And parties before the court must take the court seriously. Otherwise, you seriously disadvantage the court if you do not put your side of the case. Here is it, sir, that he waits, or it waits, rediffusion, until November 1995, after the unless order should have taken effect on the 6th of March 1995, to tell us all of that.
Well, I do grant you, I mean, this is an aspect of the matter that did strike me. That it was not until the 28th of November 1995 that they actually got around to filing an affidavit, which was some 8 months after Sir Henry had joined the team.
So they did not help the court to help them. The court could not have imagined what it is that they have to say that they have not said. The court could not have done that. It was not fair to the court system that they should now be complaining. They did not help themselves. And they wait until after the order of the Chief Justice had taken effect. He said up until the 6th of March. And they gave an affidavit. If that affidavit had come on the 1st, had verified the discovery on the 1st of March, 4 days or 5 days before the unless order was to take effect, it might have put a different complexion in the whole thing.
There was an affidavit verifying it, but it was very short. It explained the reason why they could not.
It was not helpful. It didn't help their case. And that is part of the problem, sir. That is part of the problem. But I think, sir, that the record should show, sir, and the court's attention should be attracted to the case of Tracy and Crane Estate Limited and another. It's a Barbadian case, sir, which is to be found at tab 2, I think, sir, tab 2. No, tab
3.
Tab 3, sir. Tab 3 of the list of authorities.
This is the blue one.
Tracy, Tracey, and Crane Estate Limited. I'm reading, sir, at page 67, letter B. The case is 59 West Indies Report. 59 West Indies Report, starting at page 64. 2059 West Indies Report. And page 67, letter B, discovery of documents. It is a well-established general rule that statements in a party's affidavit of documents are conclusive as to whether he has or had any documents other than those disclosed. The general rule is subject to the right of the other party or parties, 1, to apply for a further and better list, and that is what we did, sir, in relation to the first affidavit, verifying the documents. 2, apply under Rules of the Supreme Court, Order 24, Rule 7, for an affidavit as to specific documents or class of documents. In the former case, that is where you have applied for further and better list, as happened in this case, the application may be made where it is apparent from the list itself, or from the documents disclosed in the list, or from admissions in the pleadings or otherwise, that the party's list is incomplete. Such circumstances are exemplified in Kent Coal Concessions Limited in Dugit, 1 King's Bench, 1910-904, Court of Appeal, affirmed by the House of Lords at Appeal Cases 452-1910, where a further list was ordered of the primary documents from which a disclosed balance sheet was compiled. The very basis of the application precludes the need in most cases for an affidavit in support of the application. So that in our circumstance, particularly in relation to the first list, which led to a further and better list, it is clear that the conclusivity doctrine, sir, cannot apply here. Because it was when that first order was made in November 24, and there was no response, that they came back to court.
What was it, do you say, that triggered your right to go behind their affidavit?
Because there was an order made pursuant to a request for a further and better list. I say further that apart from Mrs.
All right, and when they then filed a further and better list, or a further and worse list, whatever, which they verified by an affidavit, they said, look, this is all we have. What justified you, when I say you, your side, in going behind that affidavit?
And that is contained, that principle, between letter C and D. In the former case, sir, we have applied for further and better lists. The application may be made where it is apparent from the list itself, or from the documents disclosed in the lists, or from admissions in the pleadings or otherwise, that the party's list is incomplete. It was clear, sir, without even Mrs. Ram's affidavit,
No.
Yes, without military, without using on Saturday. You say it is clear.
Even without that,
Yeah, I think it's
the court was entitled, on the basis of the pleadings, to entertain reasonable suspicion that this could not have been a sufficient and adequate list.
why?
Because, given the nature of the pleadings, sir, this clearly was not all the material that was invoked. Not using the common sense assumption that a reputable broadcasting company is bound to have had more. We must never abandon our common sense in the adjudication of these matters, so the court cannot afford to do that.
But aren't we trying to apply the first limb exception under 67C in the former case? That's what I think we are trying to see. How does that principle justify you going behind the further and better list of the 1st of March 95?
Well, the answer for what, which I suggested before, is that the fact that they were playing which was indicated by the fact that they had the record.
You're basically saying that a reputable radio station must have been able to produce a better list than the first one that was supplied. Is that it?
That's an influence.
That is correct. But it's something which is from the document, from the disc. They have the disc, they're playing the record. You used to have a radio station and you don't have any records of what you think it was. Never had. I think that it's sufficient to give right to this. No, because then you have the common court the fact that this presumption of being reported is made before someone yeah. And then of course you have him coming out and a meeting.
But you're right. The court on its own, as I understand the doctrine, the court on its own could have entertained a reasonable suspicion, given the nature of the pleadings and reasonable common sense assumptions. Now the court had good reason to ask for further and better lists, resulting from the first list. But the second list was a worse list than the first list. So you answer an order for further and better by making a worse one. That itself seemed to me so would have provided a foundation for going behind that second list as well.
You're saying it's worse because they failed to disclose the tape rather than and instead substituted a recording?
They substituted the recording and failed to give any explanation as to how that occurred. They say it's either error or inadvertence.
Well, it's not a matter, according to the authorities, to be explored in the trial.
That is not how I understand them, sir. Because there's a lot of learning in Malek and Matthews.
There is also a lot of learning, a lot of judgments, which say that really you don't want to get involved in a lot of cross-examination and so on when you're dealing with an interlocutory matter. And I would have thought, subject to what you may say, I have a little difficulty in seeing how a court of appeal can reject the sworn evidence of a person without his being cross-examined, without even seeing him or hearing him give his evidence. I have a little problem with that.
I wonder why, sir, for this reason. You may forgive that, sir, but As I understand it, sir, Lord Green spoke about it in Harrison and Lawson and Oldham Press Limited, and I'll draw the case, specifically the 1948 case, to your attention. And he makes the point very firmly. And he said that he was relying too on the experience of the Valentine homes, that for 50 years and more they did not know of cross-examination and interlocutory proceedings.
Well, that's what I'm saying. I just said that.
Yes, but it does not prevent the court from drawing inferences in favor of one party or the other, or even rejecting the affidavit of one party. It is no bar to the court drawing inferences, because there's been no cross-examination.
I'd like to hear you why we should reject, or why the Court of Appeal was right to throw his sworn statement out of the window on the basis of what?
The court made its own analysis.
Well, what was this analysis based on?
Based on the history of the events in the matter, and came to the conclusion that he was not worthy of belief.
Well, I fail to see how the history of the matter can cast any light on the credibility of Mr. Fernandez. The history of the matter was largely, as you have said, in the hands of the lawyers anyway. How can he be deemed a liar because of the history of the matter?
Well, then the lawyers work on instructions, and then there should have been some explanation as to why the lawyers did as they did. They could only have worked on instructions. The lawyers are only agents, and we must not make them principals.
Yes, okay. That's good. Go on.
Now, sir, the court found, the Court of Appeal, and my learned friend didn't seem to appreciate the sting in it, that the affidavit was cleverly drawn, which was a euphemism for saying that it was dodgy.
I suggested cagey.
Cagey, yes, and I did record that, but at the same time I had earlier recorded dodgy.
You like dodgy?
Yeah. The point is, sir, that a court on the basis of affidavit evidence, and this has been the history of interlocutory proceedings, is entitled to draw inferences and to come to conclusions, even conclusions adverse to a party. And this is what the court did in this case. I was trying to find for the court, sir.
I have any case in which the court in discovery proceedings made a finding of fact in the teeth of the affidavit evidence of a witness who was supporting the discovery that had been made. I would be very interested in seeing it.
I'm attracting attention, sir, to page 11 of the written submissions.
Yeah.
Page 11, sir. The last paragraph, as we say, sir. Page 11.
Paragraph 31?
Nope. And that is tab. Yes, it's the written, it's the skeletal, sir, written submissions.
That's of yours.
Yes, sir. Paragraph 31, sir. Type page 11, sir. The judge was fully entitled to draw all proper inferences of fact from the affidavits before him, including those of Mr. Fernandez. That's their submission, sir. He was not prevented from drawing such inferences by the fact that Mr. Fernandez had not been cross-examined. In any event, cross-examination in interlocutory proceedings in Barbados is highly unusual and never occurs before the Court of Appeal. C. Lawson and Harrison versus Oldham Press Limited.
I may just ask you to pause a minute and come back. If you read Mr. Justice Husband's judgment, it would appear that his starting off point was that there had been non-compliance with the order. That's where he started. So that to say that he reached that by inference, or how he reached it, is pure speculation.
I wonder why you say that, sir.
Well, I wonder why you keep asking me why I say things.
Because
I would have thought it was obvious, Dr. Chandam.
No,
but
sir.
By all
I'm
means,
afraid
keep wondering.
the obviousness of it escapes me, sir, and for this reason. Justice Husbands came to the striking out order pursuant to the application, sir, when the case had a history. He didn't come in a situation where there was a blank slate, there was no history. The order of the 20th of February, which he was concerned with, said that unless they comply with that unless order, the order with an unless provision, by the 6th of March, they should be stricken out. So that the single question, the simple and single question that are filed for determination by husbands on the summons for striking out was whether or not that discovery of the 1st of March, which was less than the discovery in November, was compliant. The court had ordered a further and better list, and they were met with a worse list. So that it would be difficult not to sustain the conclusion of husbands in all the circumstances that the discovery was not compliant.
The use of the adjectives worse and better.
Less sufficient.
Or less sufficient.
Less
sufficient from what or from whose standpoint?
From the standpoint of the pleadings and the affidavit of Mrs. Ram, all of which form uncontested, all of which inform the court's judgment in asking for a further and better list.
When the order was made,
Sorry, you go ahead.
did the judge in the order state what he looked at upon in the order itself, upon reading so and so? What did he refer to as?
He's referring to the affidavit of the 12th of October. Yes, that affidavit that was never resisted. You see,
but in the judgment, which he had given mature consideration over a period of 3 years, he had never asked the question, was there compliance? He never sought to pose it or to explain why or how he was answering it or why. If you read the judgment, Dr. Chandler, if I may suggest respectfully, you will understand what I am saying. That his starting off point was non-compliance.
So that was the issue before.
He may have had wonderful reasons for doing that, but we don't know what they were.
Several points in response about the husband's justice. Husbands was not...
We should call him Mr. Justice.
Justice Husbands. I'm so sorry, sir. Justice Husbands, sir, had a single issue before him. He was not writing or addressing a jury. He didn't have to address every issue. There is no format with respect to how judges write their decisions. We are attacking process. As I understand the law, it is the decision that is appealable, not the process. Sometimes the process helps to defeat the conclusion. But it is the conclusion or decision that is appealable, not the process. I've been told that repeatedly by courts across the region. If therefore the decision is sustainable, and that is the question for this court.
But is that a reason not to give reasons?
When you look at all...
Because your reasons may be wrong. Surely that can't be the right approach. Get it?
If the decision on the evidence is correct, it matters not that the reasons may be wrong. But it is not hard to know what were the reasons given all the circumstances.
Right or wrong, you should at least give them.
Well, you know,
especially after 3 years.
This notion of reasons is relatively new in England in the last 10 years. Much has been said about reasons, but not every case calls for reasons, especially when you are not dealing with a jury. It was clear, as the Court of Appeal found, to read into husband's judgment, Justice Husband's, what it is, sir, that inform him. He found implicitly, in my view, that there was non-compliance, and he found explicitly that the behavior was contumacious. And these were the two issues that fell to be determined. And that is exactly what the Court of Appeal also found. They found, both of them, explicitly, that there was non-compliance and that the behavior was contumacious. Husbands found on those two issues of fact, implicitly non-compliance, and explicitly, in the last paragraph of the judgment, contumacious behavior. So that we have concurrent findings of fact. The fact that one was implicit is not to lay the fact that it was a finding. Because in logic and in language, we speak either explicitly or implicitly.
When we talk about a finding, usually it comes at the end of an analysis of facts. You say, these are the facts, this is my finding.
Well, there is
if you just simply start with a premise, how is that? A premise is not a finding.
I think myself that is to be excessively critical of husbands. So he had a single issue, Justice
I don't know why you keep calling him and taking away his title when you are supporting his judgment.
Not deliberate, so perhaps because he's out of the system now, we forget the judge part. When I see him at times, it says, "Judge, how are you?" He says, "No, drop that. I'm no longer judge." So you must forgive that, sir. No disrespect at all meant, sir, but
I'm sure.
But he said that on the review of all the authorities and the submissions of counsel, so he relied solely on that. He didn't amplify or go into any reasons why he accepted one set of submissions as against the other.
It's like counsel who tell you all the authorities show so and so and so. See what you mean?
You know,
which authorities? Well, I thought you knew some law, but all the authorities show.
But what we are doing, sir, is really saying that there must be a particular format for writing a judgment. And the formats vary from A to Z.
No. Anyway, let's not stick on this point too long. We're already exhausted. Let's move on.
I think, sir, that we should have before us, and I do so now, put before the court, so the Biko case, which is the case of the Trinidad that has recently come out of the Privy Council, Biko and Brooms.
Beckway is actually pronounced. Beckway.
Well, I'm grateful, sir. We in Barbados are hard on vowels and.
Yeah, well, this is, I believe, not an English word. It's supposed to be
it's an African word, yes, and I take your guidance from that, sir. Beckway and Brooms.
Before you go on to that, do you think that the Privy Council's policy in regard to not interfering with concurrent findings has anything to do with their distance and lack of knowledge of local conditions?
Wouldn't have thought so. I regard it, sir, as a salutary principle, except in the rarest of occasions, sir.
Except?
In the rarest of circumstances. Must be a salutary principle, sir, and there must be some element of finality too, sir. And the behavior of the defendant appellants, in this case, their conduct, sir,
I wondered how much of it was attributable to the acknowledgement that maybe the local judges know something we don't know.
Well, There is that element, and often they say that this matter was best dealt with by the local judges, but I don't know, sir, whether this principle was, as it was developed, Lord Thankerton, and even before, Debbie and Roy, 1947, and even before, had anything to do with that.
Well, they were even more distant than that because there were no jet planes.
No jet planes, sir. I believe, sir,
no telephones and overseas.
It is possible, sir, that as this...
Alexas and, computers and so on.
Perhaps
anyway, you go ahead.
When the CCJ becomes a busy court, sir, with several cases a week, sir, they may find the principle useful too, except...
I'm grateful for your concern.
Except, sir, there has been a clear injustice, a clear error of law, an abuse of the discretion. Unless we can point to any of those things, sir, I think that the principle should be respected, sir. And given, sir, that the majority of the jurisdictions in the Caribbean, sir, are still before the Privy Council, sir, it would be a very sad thing, sir, if we should have two levels of justice in relation to these matters.
Well, I don't know what 2 levels.
2 responses for the similar type of situation. I think that would be undesirable.
That might be a better approach to justice. Think about it, but go on. That's the rest of your submission.
The Quasi-Biko, Kwasi Biko, and Horace Broom, sir, it is at tab 21, sir, of the cases. It's a case that came from the Court of Appeal of Trinidad and Tobago. I see Chief Justice Sharma, Justice of Appeal Jones, and Justice of Appeal Warner, sir.
I think that's an error, because actually the court was Justice Jones, myself, and Warner.
I hope that your exclusion, sir, was not deliberate, sir.
Maybe could be deliberate.
Now,
no, he didn't do it.
I have my markup. There was in this case, sir. Sorry, sir. An attack on the trial judge, sir. And it was felt, sir, that he did not give enough reasons, that his judgment was perhaps too short. And the Privy Council said it, paragraph 9, sir. In the middle of the paragraph, sir, that an appellate court ought to act very cautiously before deciding to overturn findings of fact by a trial judge, even where it inclines to the view that the trial judge's treatment of the evidence in a written judgment had not been as fair as it might have been. Following his consideration of the evidence and the findings of the trial judge, Jones, J.A., Justice of Appeal, stated his conclusion that he saw no reason to disagree with those findings, and with the concurrence with the other members of the court, dismissed the appeal. And indeed that is what happened here too. On appeal to the Privy Council, Mr. Marcus, Senior Counsel for the appellant, paragraph 10, sir, sought to place before the board a large number of considerations on which he relied, as tending to show that the trial judge and the Court of Appeal did not adequately analyze or give sufficient weight to the evidence and failed to adjudicate on the trial material in the appeal. The last few words of this sentence contain a very faint echo of the principles on which the board acts in cases of concurrent judgments on issues of fact. Since these principles found no place in the written submission of the parties to the present appeal, their lordships consider that it is necessary to issue a reminder of their existence and re-emphasize their importance in cases of this nature, which come before them. These principles, paragraph 11, constitute the practice adopted by the board for application in cases of concurrent judgment of two courts on a pure question of fact. That is to say, where an appellate court has reviewed the decisions on factual matters of a trial judge and reached the same conclusions. I pause here to say that the two issues were whether there was complaints by the list of the 1st of March 95, and the second issue was whether the behavior was contumacious. And on those issues, both courts found the same way.
This was a defamation case. And
this too was a defamation case.
yes, but in this case, there was a trial. And what the Privy Council is saying is, look here, on the question of whether there was the judge properly analyzed the facts and arrived properly at the conclusion that the statement was libelous.
Whether it was made.
Whether it was made. Yeah, that we would defer, yes, whether it was made, we would defer to the findings of both courts. They were not prepared to get into that argument because it wasn't something that local judges, it was something that was said on the telephone. They were prepared to rely on the findings of the local judges on that point. So I don't think that is quite on all fours with our position here. Dealing with findings of fact before any trial.
No, I was
in fact without cross-examination.
I was concerned to emphasize the principle applicable. There's sometimes it is hard to find the cases on all fours, but it's the applicable principle.
Does it apply in philosophy context where there's been no trial, there's been no testing of the evidence by cross-examination?
And that means that I have to go back to Lord Green in a moment, but I'll just complete this paragraph 11. It is rather a rule of conduct. I go back further. It is rather a rule of conduct gradually developed, which the board has laid down for itself. In such cases, the board will decline to review the evidence for a third time, unless there are some special circumstances which would justify a departure from the practice. In paragraph 12, to deal with Lord Thankerton and Debbie and Roy, 1946.
You're reviewing it for the second time.
Sure. And they restated the principle. Yeah. My submission on this, sir, is that even though Justice Husbands, get it right now, even though Justice Husbands made an implicit finding rather than an explicit one in relation to the question of whether there was complaints, whether that list of the 1st of March was complaint, that we ought not to quarrel with that, sir, because the fact is either explicit or implicit. The second thing is, sir, that on the second question of whether behavior was contumacious, sir, he was guided by all the relevant and correct learning. And he came to the conclusion, sir, that the behavior was contumacious. The Court of Appeal found the same facts, sir, on the two issues. And so, on issues of fact, we have concurrent findings. And that is what I would urge with respect, sir. And that the attack on the process avoids the question of whether, given your unhindered lookout, this court has...
I'm sorry to belabor the point, but is there really anything at all in Mr. Justice Husband's judgment which would indicate that he did not assume that non-compliance had been established, and that he did not have to consider whether there had been non-compliance or not? I mean, is there anything at all that would give us that any sort of reassurance that he appreciated that that was an issue which he had to decide.
I would be making a harsh and adverse assumption, sir, if I were to accept, sir, that he did not know what he had to decide. It was clear as day that he had to decide whether the order was compliant. Metropolitan nominee, Grand Metropolitan nominee number 2, he was guided by that principle. He was guided by high tech. He knew who had the burden of proof in the matter with respect to contumacious conduct. He knew all of that, sir, and he referred to the authorities, sir. I know of no good reason why we should assume that Justice Husbands did not know what he was doing.
I am not saying that we should make any assumption either way. What I'm asking is whether you can point to anything in the judgment, anything at all, which indicates that he was aware that that was an issue which he had to decide.
Sir, I have no difficulty, sir, in concluding, sir, that he knew what he had to do. We can quarrel, sir, that he could have been more expansive. He was perhaps too economical, sir. But it seems to me that what the Court of Appeal did was not necessary. They went further. And I reject the argument that there was uncritical acceptance of husbands. They went further. And there are the Court of Appeal, sir, and they actually identified, sir, what the documents that should have been disclosed were. So there was no uncritical acceptance of Justice Husbands in that regard. And that is part of the criticism that has been made here today. And in the skeletal, sir. But I do not accept that to be correct. But was that necessary? I'm not sure that it was necessary. So the questions were two. Was there compliance in the list of the 1st of March, 95? And assuming that there was non-compliance, was the behavior contumacious? Yeah.
I think you're saying, Dr. Cheltenham, that the learned trial judge, although he did not expressly state it, he obviously was not impressed with the explanations given in Mr. Fernandez's affidavit. You have to infer that because he doesn't say so.
All of that seems implicit.
And he therefore came to the conclusion that his conduct was intentional and contumacious.
Yes.
I mean, he doesn't say so at all at any stage of in his decision. But you're saying that he must have looked at it, and he must, based on the authorities and based on the submissions made by counsel, he must have come to that conclusion. Isn't that correct? That's the only way that you can.
That is correct. And I go further.
And that there was a non-compliance.
Yes, that's the first finding, implicit. And in the end, and we look at that, but I just wanted to attract attention to tab 22, the case of Lawson and Harrison. Lawson and Harrison versus Oldham's ODHA MS Press Limited, 1949, 1 KB 129. And that's to be found at tab 22.
Yes.
And also paragraph 31, sir, of the, it is quoted at length there, sir, paragraph 31, page 11, of the skeletal. Paragraph 31 serve the skeletal. And we have a fairly elaborate quote from Lord Green saying, "But I'm bound to say that I'm happy to hear from Sir Valentine Holmes that in his experience it is not the practice, in the absence of special circumstances at any rate, to allow cross-examination on an affidavit of this kind sworn in interlocutory proceedings. It appears to me that if such practice existed, it might be said to be a deplorable one, because it would mean that actions of this kind are subject to the multiplication of expense by cross-examination in interlocutory proceedings. The question of whether or not cross-examination ought to be allowed is a matter of discretion. I only express the hope, if I may properly do so, that in interlocutory proceedings no such order will be made in the absence of special circumstances of some kind." And that seems to be the practice both in England, and certainly it has been the practice in Barbados, that it is rare in interlocutory proceedings for cross-examination to be permitted, and it does not prevent the court from drawing inferences arising from the affidavit evidence without any cross-examination. No bar to drawing of inferences.
But you mean inferences as to credibility?
Even inferences as to credibility, because
Does the Lawson and Harrison case take us that far? Does it deal with the credibility in a situation?
I am more attracted here to the general principle. It seems always so easy to say, but in the circumstance in which the principle arose, the facts are not on all fours, but the principle transcends the facts.
Yeah.
It is a general principle. And an affidavit may be so contradictory. It may both condemn and attempt to exculpate at the same time, as we submit was the position with Fernand's affidavit of November 95, that it were possible to analyze it critically and to come to the conclusion that it was not worthy of belief without having to see the demeanor of the witness.
Part of what I described as Fernandez's caginess was the way in which his admissions were not very frankly made. They were not very. They did not sort of declare themselves to be admissions, but they were. It would appear. But the fact that he made them, we tend to suggest that while he was cagey, he wasn't a liar. Because if a liar doesn't necessarily have to be cagey, he just lies. And says that in this context, Fernandez might have denied that they had any long tapes at all at any stage. He could have done, but he didn't.
But would the fact that a court might be inclined to come to a different conclusion be a sufficient reason for overturning the findings?
Well, there is no magic in the findings. Not as though there was some, there was some sort of inspiration which led to the findings which we do not have the benefit of.
You see, because in the end these are matters on which men of good judgment and rich experience may divide. And if 7 men have come to the conclusion thus far, I don't know why others should say, but we disagree, because there's no point of principle in it. There's no point of principle in that.
Well, let us, without disagreeing with their findings, let us look at what the Court of Appeal found. And, I think that it's very important to analyze this judgment, as well as the affidavits by the respondent and by Mr. Fernandez. And far as I can make out, they were not able, the Court of Appeal were not able to come to any conclusion that there was any document in existence at the time when the further and better list of documents was filed. That was in the possession of the defendant and related to the matters at issue. They found that certain documents some had been admitted to have existed, and others, in particular, the tape of the Calypso competition. They found, despite what Mr. Finance said, they found that it more likely than not that there had been such a tape. That's on page 10. Page 295 of the record. But the point I'd like to draw your attention to is at the end of the day, if one accepts the Court of Appeal's findings, what you have now is, by way of the crime, is that they did not disclose certain documents which had been, but were no longer in their possession, and some of which, at any rate, at least all of which, with the exception of the tape of the contest, live broadcast from the competition, all of which had been disclosed are in the Fernandez's affidavits, not at the time at which, nor in the form in which they should have been disclosed. Now, I'm taking that as a basis, and if we apply the principles of proportionality and balance, then with the striking out of the whole of the defense, and I emphasize the whole of it, have been appropriate or justifiable.
I would respond by saying yes, and I would say further in relation to Fernandez that the Court of Appeal obviously felt that he was not worthy of belief. I mean, you are stretching it. Look at it.
I'm sorry to interrupt you. Is it that they didn't find him worthy of belief, or that they operated on the basis that what he was saying was true, and said on that basis there was material that should have been disclosed, material that they once had but they no longer had?
Up to a point, there is also yes, I know.
But I think that question of belief does arise because at paragraph 28, they did say that we find it very unusual and stretching credibility.
Yes. They didn't believe him.
So that means that
they didn't believe
implicit in that is that they did not believe.
But we must bear in mind that Fernandez was not in a position to say, nor did he purport to say positively, that there was no tape made of the competition. He said that he certainly had found none, and that he had questioned the people who were involved in that exercise, and they all denied. They said that that the tape hadn't been made. But he went on to say that in any event, if it was made, and he didn't deny the tapes were made sometimes of these live broadcasts, that they would have had a very short shelf life. That it might have been played to show the crowd reaction and so on, But they had no reason to keep it because of the inferior quality of their recording. And since they preferred to play the vinyl recording. So I don't think that, this wasn't a finding that he had lied. But they were drawing a different conclusion, although what he said pointed in the opposite direction.
They stopped short of calling him alive.
They didn't. I mean, they couldn't because he did not purport to say anything more than what I have outlined in relation to that live broadcast.
They use a robust common sense approach, which this court will do, I have no doubt, and has been doing this morning in the questioning, the dialogue. And they said at paragraph 28, we find it very unusual and stretching credibility. Now these are euphemisms for we don't believe you're telling us the truth or you're not telling us all the truth. This is the language of euphemisms, diplomatic language, the language of urbane men, sir. But we must be in no doubt what it means. We find it very unusual and stretching credibility to accept that a responsible broadcast organization such as the applicant defendant would do a live broadcast of such significant events. Now these are premier events in the cultural life of Barbados. Pick of the crop finals and semi-finals. In good years we throw up 20 and 25,000 in a population of 250,000 to these events. As the pick of the crop semi-finals and finals without having made a tape or other record of the broadcast of those events.
What I'm saying is that what they are disbelieving, not really statements made by Fernandes, by statements made by the people whom he questioned.
Well, so that too raised questions. Who were these people?
Well, that's
when did he question them? What did he ask them? You see, the affidavit led to all of these questions about his inadequacy.
So there should have been cross-examination.
No. He had a responsibility to come clean, and he should have come full, adequate, say everything, keep back nothing. So they go on at paragraph 29 to say, in all the circumstances, it is not unreasonable to conclude that the defendant had recordings or tape of the live broadcast of the pick of the crop semi-finals and finals, that they may be recycled or otherwise disposed of, and that they did not include them in their list of documents as documents which had been but are no longer in their possession. We hold therefore that the applicant defendant did not comply with the unless order made by the Chief Justice.
Is it only on that point that the conclusion is on the absence of the statement in the second part of the schedule as to documents which they had but no longer now have? So that if they had, what they're saying is that had you put it in your had but no longer have sections, then that would have been a perfectly good list. Can we draw that conclusion from 29 and 30?
You may, but I would at the same time urge that you draw the consequences from that, because you misled everybody, the other side and the court. You prolonged proceedings, and now after 13 years we are still interlocutory. It was a serious thing.
This is what we're talking about, live broadcast of the events.
It was a serious thing.
And that was pleaded, was it? Live broadcast?
Yes, we did plead the verses. We did plead the verses, and the whole discovery process was concerned about that.
No, but all I'm on is that, where is it pleaded that live broadcast?
No, live broadcast was not pleaded. Recorded calypsos. But as the case developed through the interlocutory stage, there could be no doubt that that is what we are talking about, so much so that the Court of Appeal's decision reflects the absence of material discoverable in relation to the pick of the crop finals and the semi-finals.
It may be said, although Sir Henry has not said it, that really if these documents had been disclosed in Schedule 2, the plaintiffs would be no better off than they are now. Would they? I don't know that they need some qualification. But, sorry?
This is 10 years of litigation.
Yes. Yes.
We reject the contention, sir, that a fair trial is possible. We say to begin with that it is not the test of contumacious conduct. That contumacious conduct, as Ward L.J. said in the high-tech case, embraces a larger consideration. It has to do with the public interest in the administration of justice and the court's ability to regulate its business and maintain order. It's a larger issue. And that's made very clear in the high-tech case. Whether a fair trial is possible is not a test of contumacious conduct. That's not the test. But we say that in any event, a fair trial is not possible here.
Would you say that the main defense to this action was justification?
But that is the only surviving defense now.
Well, it doesn't survive, does it?
That is the only surviving defense in circumstances in which
It's not surviving.
there is no...
Otherwise you wouldn't be here.
Otherwise, in circumstances in which they have not admitted that they ever broadcast the material.
I know. But the other question is that the documents, even the documents which the first respondent alleged they had nothing to do with the justification plea, did they?
I'm trying to remember, sir, short notice, that first document, sir. I think it consisted of 3 tapes, 3 records.
Yeah.
3 records, November 93.
You had two,
The documents which
records in
you
one tape.
complained,
Yes, 2 records and 1 tape.
which they should have disclosed but did not. They did not have any bearing on the plea of justification. Do not have any bearing on that plea. Agreed?
That's a question of construction. In the end, as to whether and belief by a jury or a tribunal of fact. Now, a judge sitting alone, an alert judge, will make the necessary adjustments, but with a jury, you could, if you cannot reproduce because of the unavailability of the material, you cannot reproduce the dramatic effect of what took place. And after this long passage that you may even be doubted,
The truth or non-truth has nothing whatever to do with the dramatic effect on anyone, on anything. That's it.
we are submitting so that Mrs. Ram and the plaintiffs, respondents in this matter, sir, cannot now get a fair trial, sir. Because...
But you say that because you don't like the idea of a jury.
No, well, I've spent a lot of my life before them, sir. And
No, but that's what you indicated earlier.
but the inferences, given the history of the matter, that a trained officer could make, you may not be able to persuade a jury to make. As far as we are concerned, you either have it and we can see it and understand it, or you don't have it.
Then she said that she has a copy of the tape, that she has a tape in her possession.
The 28th, first of all, there has never been any admission of a tape in the discovered material. The list of days for which she says that she has a tape. of the finals. That is to begin with, the 4th of August.
That is made the subject of complaint by the other side. They say that you have been guilty, your side, of non-disclosure, because you swear an affidavit at which you refer to this tape, and in fact you quote a verse from it, but that tape is not mentioned in your affidavit, in your list of documents.
Well, that is based on assumption that the source of that was a tape in the possession of the plaintiffs. You see, immediately after the finals, there are people who have been following the whole season who can tell you that last night in the finals, he dropped 2 lines in the 3rd stanza and he had a new stanza, and they give you every word. So that to say, as was said just a while ago, sir, is to assume that the source
I thought she said so.
of the stanzas.
I thought she had said so. She said she had it in her possession.
She said so.
The tape. I think she did.
No, but in her list, she never mentions the finals.
That's the point.
She mentions the 28th, but not in the context of semi-finals.
But in what context?
Not in the context of the semi-finals. You see, throughout the day, you are having tapes, you are having records played. So she hears it at an hour, but not the semi-finals. And the only reason why we are speculating about these matters is because the other side did not go as far as inspecting, listening to the tapes. They had an obligation to do that. Then they would not be in this speculation. But it is significant that that disclosure of the 28th does not speak of semi-finals. And all through the day, on the 28th, and in that whole period, you're having tapes, you're having records from morning till night. I think it's overnight. But that is what happens. That is what happens. Now, part of the complaint, sir, is that unless you really have the tape of the finals, where there is the competition to win the crown, and where you are having last-minute surprises, and you are having commentaries and added stances and all the rest, you don't quite capture exactly what it is you're complaining about.
But wouldn't that have been a material fact to be pleaded? I mean, if you're pleading libel, and you're saying that on that particular night it was particularly aggravated by commentary, I'd have thought you would have had to plead that. I don't know.
I think that was pleaded, so even though I don't have it before me now.
I would have thought that if...
Not in that way, I'm advised, sir, but that...
I don't know it's or at all.
Well,
As you said, I know that you are recently in the case, but I think if you have in your side has a tape,
the live broadcast,
in which there is some commentary over the music, then I would suggest that you consider whether your pleading in its present form would entitle you to rely on that.
I've already come to the settled view, sir, that an amendment will be needed to bring it in line with what had been indicated throughout the discovery process. Yes, that is the settled view, sir. But as far as discovery is concerned, sir, those were live issues throughout the discovery process.
Yeah. I don't think I'd pay this to Sir Henry. I don't think he relied very heavily on the use of the word recorded, not at any rate in his oral submissions. I think there was more emphasis in the written ones. Yes.
Before I leave, sir, before we leave the whole question of the Court of Appeal's approach to the facts, sir, that, may I remind Your Honour, sir, is dealt with paragraphs 32 to 36.2 of the skeletal. I didn't think it necessary to read it, sir, but an attempt to analyze the difficult affidavit of Mr. Vic Fernandes is made here, sir. And I am commending it to the court, sir, for what it is worth, sir. You got the whole picture?
I don't know what
Paragraph 34.1, sir. Supplemental affidavit of the 29th of January 96. Mr. Fernandes stated that log tapes, and I quote, are audio tapes kept on a daily basis which reflect everything that has been played on the station for that day. End of quote. It is clear from paragraph 4.8 earlier referred to that this log tape is the same thing as what is otherwise known as the master tape. It follows that from Mr. Fernandes' evidence that there must once have been such audio tape recording what had been played on the station. Indeed, the tapes of the very days referred to by Mrs. Ram were said to have been stored under lock and key. Now that under lock and key says a quote, so it comes straight from his own affidavit. So that the point that I'm trying to make, sir, is that his affidavit is properly analyzed, is bound to leave reasonable men capable of critical analysis. That not only that it is contradictory in part, but that it is not given us all. And that is what the Court of Appeal found. And though Husbands did not say that explicitly, or Justice Husbands or at all, it is clear that he must have found difficulty in accepting what came after the unless order should have taken effect the 6th of March. And it is that sort of analysis, sir, that is made throughout pages 12 and 13 and 14, sir.
No, we don't know.
Paragraph 32. I'm sorry, sir.
We don't know what documents, if assuming that Mr. Justice Husbands did ask himself the question whether there had been compliance or not, we don't even know what documents he found existed but had not been disclosed. What disclosable documents had not been disclosed, we don't know, do we?
Except that I would have thought, sir, that would have been fairly clear from the circumstances that had preceded it.
Can you help me then? What documents did he find had been disclosed? No, had not been disclosed, which should have been.
And that arises from the...
What are they? What are they, Dr. Chandler?
The affidavit of the 12th by Mrs. Ram, which I'll find in a minute, the 12th of October, in which she refers to, because one of the issues would be the period over which this plane continued. So you needed the records, whether electronic or otherwise, to tell you that. You needed the tapes relating to the Piccadilly Crop finals and semi-finals. You needed audio tapes.
What you needed? I'm asking what documents were not disclosed that existed and were in their possession.
Well, sir, these difficulties arise, sir, from his own affidavit, because he says some of the documents were under lock and key. Which means that they had them, and apparently for a long time too. Not all of them for a long time, but some of them. Upwards of 3 years. So that what I'm saying is that if we critically analyze the affidavit, a court with the same unhindered lookout as the Court of Appeal or Justice Husbands himself will find that the question, is the decision sustainable? You may find difficulty in differing from what the Court of Appeal found, which is the same thing that Husbands found, even though...
How do we know that? The Court of Appeal has indicated what documents they found were in the defendant's possession. And those documents are a good deal less in scope and number than what was described in the first respondent's affidavit.
Paragraph 33, sir.
I have no idea what documents, if any, the learned judge found to were in existence. We haven't a clue. I don't know how, in those circumstances, one can talk about concurrent findings.
The paragraph 33 speaks of log or logger tapes, otherwise known as the master tapes. 2 logs.
Paragraph 33 of what?
Of the skeletal. The written. And computer tapes or record is the third category. These are what we've been complaining of, the respondents throughout. My difficulty with the critique of Husbands, Justice Husbands, is that the attack on him is an attack on process. The question, it seems to me, is whether the conclusion, whether we are happy with the process or not, is a sustainable one on the facts. And if the conclusion is sustainable, the decision ought not to fall away, since it is the same decision that this court with the same unhindered lookout would come to, even though through a more elaborate process. And that would be my concluding remarks in relation to that, sir. And I think that a good point at which to conclude, sir, would be the reference to the high-tech case, sir, which sets out a lot of relevant principles.
Stand for unknown. Nothing, I don't say anything to me that makes sense. I think we should still go through that.
Yeah. Let me see yours written up there. Okay. Yeah, very good. Which part of the You can read that, so before 40 pages.
Is there anything else? No.
To attract the court's attention to the high-tech case, which is at tab 9 of the cases, and to paraphrase Lord Justice Ward, who said that the unless order was a last chance for the appellant to provide proper disclosure. It was a last chance once default was established, and the most compelling reason was required to avoid the sanction of striking out, and no such reason was advanced. And to conclude, sir, I would just like to carry the court to the summary of the respondent's submissions at paragraph 58, page 23, sir, of the skeleton. And we say this in conclusion, sir, that since the orders were never appealed, it is not open to the appellant to challenge either the Chief Justice's orders of the 24th of November, 94, and the 20th of February, 95, or the basis on which they were made. The premise underlying the making of the orders was that the appellant's list of the 12th of October was substantially defective, 1994 that is. Had the Chief Justice not been satisfied of that fact, he could not have made the orders. 2. In these circumstances, compliance with the Chief Justice's unless order necessitated the service of a further and better list, whose contents went substantially beyond those of the list of the 12th of October 94. In no material respect did the appellant's further and better list of the 1st of March 95 go beyond its original list. There was therefore a failure to comply with the unless order. 3. In the absence of any application to revoke the orders, if the appellant was to escape the automatic consequences of the unless order and avoid its defense being struck out, a burden was on it to demonstrate that its non-compliance was not contumelious. The appellant failed to discharge that burden. Indeed, the evidence of Mr. Fernandez demonstrated that the appellant had once had relevant records and tapes which it had never disclosed in either Schedule 1 or Schedule 2 of its list. In these circumstances, it cannot be said that the evidence of Mr. Fernandez that the appellant no longer had the documents was conclusive. In any event, the orders of the Chief Justice required more. The evidence of Mr. Fernandez that the appellant no longer had the relevant records and tapes led to the inference that they had been destroyed by the appellant, either after being put on notice of the claim or after proceedings were brought. This destruction of relevant documents has robbed the respondents of a fair trial. And finally, sir, if it be necessary for the respondents to establish further prejudice, the conduct of the appellants has caused them prolonged delay in bringing the case to trial and in vindicating their reputation, sir. And on that point, sir, I rest, sir.
Thank you, Dr.
Thank you very much, sir.
So, Henry, is there anything in reply particularly?
Most of the points have been raised and dealt with.
I think so.
I'm saying in the Lawson case that there actually was cross-examination.
Yes.
And that Mr. Hedo, I think our Hedo was cross-examined. I would just like to express to you, in the interest of the future of Caribbean jurisprudence, that I believe that it has been the purview of this court to review the practice in relation to concurrent judgments. It's obviously from legal history that the Privy Council was in many ways influenced by the pressure on the House of Lords, which had to sit in both capacities. And in some instances of our jurisprudence in the Caribbean, it limited itself, therefore, to not taking on what it thought the local judges would have done better. But in the light of the development of fundamental human rights in the European Human Rights Convention, which mirrors some of our constitutions, I think we are looking forward in the future to some development along this line. A general comment.
Thank you. Well, we are going to rise for about 5 minutes and then return.
All right.
We are very conscious of the need to get on with this action, and therefore, since we are clear in our minds as to what order we should make, we propose to announce our decision now and make the order now, and give our reasons later. I don't think I will attempt to explain the basis of the order, which will speak for itself, because I think it would be better to leave the reasons to be given more fully and more maturely in our subsequent judgment. We have the decision of the court is that the order striking out the defense should be quashed and should be replaced, however, by an order which is in less drastic terms. And it is that certain paragraphs of the defense, the amended defense, be struck out. Those paragraphs are paragraphs 2, 3, 5. In paragraph 6, in the second and third lines, the words "if" this is referable. If referable to any of the plaintiffs, which is not admitted, those words are to be deleted in paragraph 6. And paragraph 8. To put the matter in the same, to produce the same result, but in a positive form, what we are doing is restoring the following paragraphs of the defense. Paragraphs 1, 4, 6, except for the words I've mentioned, and 7. Now, the effect of these amendments which are made by us is to leave the in existence the plea of justification, and also we have not struck out those paragraphs in which no admission is made as to the matters of inducement, as to the damages, and as to the innuendos pleaded. Those are the matters which are still preserved. And one effect of this order, we hope, will be to reduce somewhat the length and complexity of the trial, because the effect will be to narrow the issues to the issues of justification and damages. The plea with regard to reference to the plaintiffs is not restored. The denial of reference to the plaintiffs is not restored, and nor is the challenge of the allegation that the calypsos were broadcast by the defendant on its radio station, Voice of Barbados. And it was during the period which is pleaded, and within the area that is mentioned, Barbados and the Eastern Caribbean. As I said, I don't need to attempt to summarize our reasons now, but it will be clear from our order that we think that the conduct of the defendant is worthy of being visited with some sanction, though the sanction which we consider appropriate is a lesser sanction than the one which was imposed by the judge. And we will explain more fully, as I said, in our reasons, the underpinning of the order. Actually, the consequential part of the order made by Mr. Justice Husbands, namely that the judgment he entered, damages and costs, is also quashed. And the other orders made in the matter to date stand. With regard to our costs, we are first of all order that in relation to the application before which was made by summons in the High Court, and which was heard and determined by Mr. Justice Husbands, that the plaintiffs should have half of their costs of that application, obviously on the basis that they were entitled to bring that application and were entitled to an order, though not the one which they sought and obtained. With regard to the appeals against that order, both to the Court of Appeal and to this Court, including the cost of the application for leave to appeal, which was for special leave to appeal, which was made to this Court in August, and which were reserved to the hearing of this appeal. We order that those costs be the defendant's costs in the cause, which means that if the defendant succeeds ultimately in the action and a general order for cost of the action is made in its favor, it will recover as part of those costs the cost of these appeals. If, on the other hand, the plaintiffs succeed in the action and get their costs of the action, the cost of these appeals will not be included in the costs payable to them. Are there any questions with regard to the order? And I would merely, as I indicated in the course of the argument, we would have been prepared, if invited, to make any other order that we have power to make, which would facilitate the future expedition or the expediting the future course of this action. But I understand that counsel would not have come prepared to make an application of that kind, so we have none to deal with. But I certainly hope that, again, I repeat the hope which I expressed on the occasion of the application for leave, that the matter will, with the cooperation of counsel on both sides and their instructing attorneys and the parties, proceed with the utmost dispatch to trial and final resolution. And I don't know, I hope that this matter will not come before us again. Of course, there is we're quite happy to deal with it if that should happen. But I warn the parties that any one responsible for further delay in this matter will be dealt with appropriately by us, insofar as we can reflect in any order we make our disapproval of any further contribution to the delays in this matter. Well, it remains me merely to thank Council for their insightful and entertaining and enlightening submissions.
All right.